have a lot of people who are participating who are experienced in veterans law, but we also have a lot of people who really have no experience. This CLE will do a couple of things. One, it will satisfy the requirements for accreditation with VA, but it also will provide you with lots of good information about how to represent veterans in the disability compensation world of the VA. So as you listen to the CLE today, you're going to hear from several of our attorneys, our staff, and our students who are in the Veterans Law Clinic. And when you do that, I'm confident you will be impressed with the people who work at the clinic and our students. And also, you're going to hear about the accomplishments of the clinic. So you may be wondering, why do we do this CLE and why do we do it every year? And the reason is because while we represent lots and lots of veterans and do amazing things for veterans, the demand for our services is greater than what we can handle. And so we need attorneys who can help veterans on a pro bono basis. And this CLE is one way to get attorneys qualified and capable of doing that. So you're going to hear about how to do that, how to help veterans and represent veterans with our assistance at the Veterans Law Clinic. So that is one of the main goals. You're going to hear about how all that works a little bit later on during the CLE. So I want to thank you for your willingness to help veterans. It is a need that never goes away, and in fact, it keeps increasing. And I think we're going to keep seeing that in the years to come. So thank you for participating. Thank you for helping veterans, and I want you to enjoy the CLE. So what I'm going to do now is I'm going to turn it over to two of our impressive students who are in the Veterans Law Clinic this semester. We have 12 fantastic students who are working in the clinic this semester. So Meg and Michaela, you want to take it away?
All right. Hello, everyone. We're excited that everyone's here today. We're excited to tell you a bit more about the Veterans Clinic. By way of housekeeping, the CLE program ID will appear several times throughout the presentation. It will also be included in an email that will be sent out to webinar participants with a link to the webpage where you can download the slides from this presentation, complete our CLE evaluation form, sign up to join our attorney referral program, and request a CLE certificate if you are not a Missouri attorney. As a reminder for Missouri attorneys, CLE credit for this webinar is only available to those who viewed it live. And finally, please take a moment to locate the Q&A function on the bottom row of the Zoom window. This is where you can submit any questions you have during the webinar. We'll make our best effort to answer as many as possible, either verbally or through a written response to the submitted question. All right, so we're going to begin by explaining what we do and why we do it. So let's begin with why. The why is easy. We do this to give back to those who sacrificed for our country. Unfortunately, our clients came back from service and have suffered illness, disease, disabilities, for which they're entitled to compensation. We fight to hold the VA accountable to its promise to take care of our nation's veterans. Another reason why we do it is because of the complex appeal system within the VA. This is the old system. You can see how messy and complicated it is. And thankfully, in 2019, a new system was implemented that seemingly streamlined the process a little bit. This is called the Appeals Modernization Act, or AMA, and you'll be hearing about that more a little bit later in the presentation. Even though there's a new system in place, the appeals process is still complex and can be very confusing to veterans. We step in and help them navigate the system. In addition to the complicated appeal system, there are very high error rates within the VA, and this can be discouraging to veterans, and many times they don't even know that they're entitled to an appeal, and they don't realize that the VA got it wrong.
So next we're going to move into how we do it. We do this through direct assistance, symposia and amicus, and community outreach through our Tigers for Troops and Show Me Home programs. The Veterans Clinic provides direct assistance to our veteran clients. The attorneys in our office represent the veterans, and the students get the opportunity to help work on these claims, much like clerks would in a regular law office. At present, the clinic directly represents nearly 150 clients. We also hold annual symposia where we highlight relevant changes and hot topics within veterans law. Previous symposia have covered topics like traumatic brain injury and military sexual trauma. Our next symposium will be held in April 2025 on the topic of combating veteran homelessness. Next, we have our rural outreach program called Tigers for Troops. Through a partnership with MU Extension, the clinic travels to rural parts of Missouri to hold free legal consultation for veterans. Since its inception, the Tigers for Troops has reached 104 counties and conducted more than 308 consultations. Finally, we have our homeless veterans program called Show Me Home. Through the Legal Services for Homeless Veterans and Veterans at Risk for Homelessness grant, the clinic works to identify veterans who are homeless or at risk of becoming homeless, who need legal assistance with VA disability claims and appeals, discharge upgrades, and/or character of discharge reviews, which can help them gain access to healthcare and other veterans benefits. In 2024, the Mizzou Veterans Clinic received a $300,000 grant from the VA to build up the Show Me Home program, an initiative to empower and aid veterans in their journey out of homelessness. This grant doubles the VA's initial 2023 backing of $150,000. The increased funding empowers the clinic to extend its assistance to more veterans, making an even greater impact. To date, Show Me Home, in coordination with VA and other community partners, has helped over 50 veterans sustain or secure permanent housing.
All right, here is why it's easy for you to help. So the VA disability compensation area of law is a very interesting and forgiving area, and the Mizzou Law Clinic will provide mentorship and support. Veterans law is veterans friendly and non-adversarial. There are no trials, no paper records, and no opposing counsel to deal with. The standard of proof is, as likely as not, a more liberal standard of proof than other areas of law. And there are few hard deadlines in veterans law, and new evidence can be submitted during the appeals process to strengthen the claims. Since the Veterans Clinic's inception, here's what we've done for our clients. We've assisted over 1,600 veterans, and these benefits not only help the vets, but countless family members. We've trained over 400 attorneys and 200 students in veterans law, and we've secured more than $16.5 million in tax-free retro payments. To give an idea of how impactful some of these cases can be, last month, 2 of our current clients received retroactive disability payments that combined totaled $500,000. But we need your help. We hope you consider joining our attorney referral program and representing a veteran pro bono. Thank you guys so much for being here today, and we hope that these presentations will inspire you.
Our first presenter today is Carter Templeton. Carter graduated from Truman State University in 2018 with a BA in communication before attending Mizzou Law and graduating in 2022. After graduation, Carter worked for a private law firm in Providence, Rhode Island, where his practice focused on appellate litigation within veterans law. In addition to his work as an attorney, Carter serves on the National Law School Veterans Clinic Consortium Board of Directors. The NLSVCC is an organization led by the nation's law school legal clinics and works with various stakeholders to advance common interests for the benefit of veterans. Carter also has experience working at multiple levels of government, having worked at the Missouri Attorney General's office and the Missouri State Treasurer's office before embarking on his legal career. Part of Carter's motivation for helping veterans comes from the fact that he has numerous family members who served in the armed forces, including both of his grandfathers who served in World War II, specifically in the Battle of the Bulge. It is from their stories and sacrifices that Carter's interest and passion for veterans law was initially sparked, which led to his current career path. Carter works remotely for the clinic from Washington, D.C., where his wife, a fellow Mizzou Law alum, serves in the General Counsel's Office of an Economic Civil Rights nonprofit. It is my pleasure to introduce Carter Templeton.
Thank you, Meg and Michaela. I appreciate it. They are both students who I'm supervising right now in the clinic, and they're doing a phenomenal job. They're making my life much easier. They're doing a lot of really great things for their clients, as all our students are. So, thank you for that. Like Brent said, it's really, really great to have you all here. I'm looking at the participant list. We've got former law professors, people who are just getting started out, people who know a lot of what's happening here in terms of the information that we're providing. But regardless, we're just really happy to have you on. Um, First, I'll go over some just housekeeping things. Like they said, we're going to be giving you the CLE program ID throughout the presentation. If I were you and I was a Missouri attorney, I'd take just a quick second to jot this down on a piece of paper, or you can just put it in your notes application. We're going to give it to you plenty of times, but that way you won't have to worry about it. I'm going to be going through some stuff today, and we do have some time at the end of the presentation for mine to answer any questions, but we do have attorneys who are ready and willing and able to be answering your questions through the Q&A function down below. So I would really encourage you to ask questions. We all understand that there's people who have never encountered this field of law before, and you're on this, and so no question is too simple. Please ask it, and that's what this is for us to answer your questions. So don't hesitate to do that. Um, just generally, I wanted to go and skip ahead a few slides to talk about getting accredited with VA. So you might be willing to do this on your own, whether it's pro bono or maybe you want to represent veterans and create it as part of your practice. We're going to be willing to support you in getting underway on that. Before I tell you how you would get accredited, I just want to encourage you to really, really think about this. I love my job. I love being able to work in this field. I'm very, very lucky to be able to say that I love my job. I think that there's a lot of unique opportunities that are available in this field. And I hope that you'll see this by the end of this presentation that we have today, but I would just really encourage you to actually think about taking this step to become accredited. So, what do you need to do to become accredited with the VA? It sounds like a huge lift. It sounds like a big ordeal. It's not, I promise. What you're allowed to do is become accredited with VA. And once you do that, you're allowed to represent veterans. There is a caveat that you can represent one veteran without becoming accredited. My info that I'm going to provide to you is that you can do that, but it's so easy to become accredited that I would just go ahead and do it anyway, even if you only plan to help one veteran. So how does that process work? So it's a VA form initially. As with VA, you're going to see a lot of it is forms, and it's a VA form 21A. So you fill that out. You can mail it, fax it, email it. There's a number of issues that or a number of ways that you can do that. It's very, very easy. It's just some very general information. So that's the initial part of the accreditation. The only part that you're really going to have to be doing something is to become to utilize CLE credits to maintain your accreditation. So it's much less stringent than your state requirements for CLE, but you still will have to participate in CLE in order to become accredited. So that accreditation process is outlined in the regulation that you see here. One thing that I'm going to say now that I'm going to be repeating a lot over the next 20 to 30 minutes is if you are encountering an issue or a question with this, please email us. You can email our general email, or you can look me up and I'm more than happy to answer questions. So if you encounter any issues or questions about this process, please just reach out to us, ask a question down below, and we would be happy to answer your question. So that's accreditation. Let me pop back up to the first part of the slides, and we can kind of get going in terms of the meat of these issues. What is the Department of Veterans Affairs? So I'm sure, as you all know, it is a department in the federal government. This is the mission and the motto of the VA. Something that's interesting that I'll call your attention to on the second part is that the motto of the VA was recently changed because it only specified male gendered veterans, and so the motto has recently been changed to include all veterans of all genders, including female. And so what's interesting about that is it was actually a veterans clinic who kind of started the process of trying to get that motto changed. I walk past the department in DC pretty often, and they haven't changed it on the outside of the building yet, but they have officially changed their motto. But what I think is more important than the motto and the general mission of the VA is actually this third part, which is VA has a general duty to assist veterans, and it's a non-adversarial process. Why do I think that that is the most important part of what lies at VA's general mission? Is because it truly is a non-adversarial process in the sense that VA's duty is to assist these veterans and working to get their claims filed and working to get their claims adjudicated, the things that are required as part of their claims in terms of getting medical records, examinations, etc. And so I think when you're going to think about what is VA's general mission and duty, it's to assist veterans. It seems clear cut and obvious, but I think it's important mentioning. So the hierarchy. This is something I love to talk about in our particular field because I think it's fairly unique. So you're going to start out at the regional office for all of the country. So there's about 60 regional offices. I think there are 57, I think. And they're exactly what they sound like. They are regional offices that are scattered all around the country. And they are really going to be the first instance where a veteran is going to encounter the VA. This is where veterans' initial claims go. This is where the requests from records come from. This is where they are adjudicating the claims, where they are making a decision on claims, and then sending those decisions out to the veterans. So that's the regional office. Now, at the regional office, you don't have attorneys adjudicating these claims. There are attorneys at the regional offices, but they're not the ones adjudicating these claims. The ones who are adjudicating these claims are federal government employees who pretty much never have a law degree, which is fine. But you do have people who are dealing with very complex regulations and statutes, and are applying those to veterans' particular claims. So I just want to make you aware of that when you're at the regional office and you're dealing with the different appeal options that will be noted in our presentation later, that you are not going to be dealing with an attorney, but you're dealing with just a federal government employee who is not an attorney. The next step up is the Board of Veterans Appeals. So the board is the first step where you're going to encounter an attorney. The board has judges, they are board judges, and they also have law clerks. So these are attorneys that are taking a look at the record and they're rendering a decision. You can have a hearing with a judge as well. These are administrative law judges, and so they are appointed by the Secretary of VA. And they are going to operate just like a regular administrative judge will. Now, the regional office and the board, they are still within the Department of Veterans Affairs. So, like I said, the secretary is appointing the board judges. The regional office and the board, they are within the department. Now, if you get a board decision and you disagree with it, then the next step up is the U.S. Court of Appeals for Veterans Claims. Again, we'll get into this a little bit more later, but the court is the first instance where you are no longer a part of the VA. The U.S. Court of Appeals for Veterans Claims is a full-fledged federal court that stands on its own outside of VA. The only thing that it has to do in terms of the VA is that it reviews decisions that come from the VA. So the judges on the U.S. Court of Appeals for Veterans Claims are appointed by the president, and they are, again, a full-fledged federal court where you're going to do full briefing, etc. Now, if you get a decision that you disagree with at the Court of Appeals for Veterans Claims, then the next step is the Federal Circuit, and then you're going to go to the Supreme Court. Now, I'll quickly just talk about why I said I really, really like talking about this in our particular field, is because at the regional office, you're not dealing with attorneys. So often, whenever I'm submitting briefs in support of claims and appeals, uh, I am not citing a lot of case law. I cite VA's internal manual. The case law, of course, applies to the regional office, but again, they're not really trained to apply complex case law to the facts at hand. So often those briefs are going to be 1 to 2 pages. They're going to be very simple, clear cut, and I'm not going to try and make a lot of legal argument. When I get to the board, that changes a little bit, and then I start to cite case law. I do some analysis of case law as it applies to facts in my clients' cases. Um, but the board has hundreds of thousands of cases to get through every year. And so even at the board, my briefs are maybe going to be 3 to 5 pages or 10 pages. They're going to be a little shorter. Then, when you get to the Court of Appeals for Veterans Claims, you're writing full briefing in front of federal judges. And then after that, you get to the point, the federal circuit, where you're at very high level appeals courts, and you get to really argue some unique things. So we have cases that often go up to the federal circuit. We've never had a case of our own that goes to the Supreme Court, but the Supreme Court has actually been very proactive in terms of taking veterans law cases. We just had a veterans law case come up. I think Bothkin is the title. And my colleague Katie Becker, who's going to talk to you a little bit later, wrote an amicus brief in that case at the Supreme Court. So at the clinic, students and the staff and attorneys get the opportunity to make simple, straightforward arguments at the regional office, but also, high-level amicus briefing at the Supreme Court. And I just want to make that aware to you, because there are a lot of opportunities here in this field in order to get to do some kind of unique things. So let's kind of get into some more substantive things. So first of all, one of your threshold issues is going to be who's a veteran. Obviously, anyone can apply for VA benefits. You have to be a veteran. So put simply, first of all, a veteran is someone who served in active duty in one of our branches. That's going to be Air Force, Army, Coast Guard, Marine Corps, Navy, and then as of recently, the Space Force. So there are some caveats to this. Generally, if you're going to go on active duty, you will have needed to have served for 24 months continuously. So those are, back-to-back months for 24 months. Again, there are some more caveats to that. For example, those who served in combat. If you served in combat, that may not apply. So I have a lot of clients who were deployed to Afghanistan and Iraq, who maybe only served for a year and 1 month, or maybe even less than a year, but they were in very, very heavy combat. They were infantry, they were hiking up and down mountains in Afghanistan, engaging with the enemy. So that might be an example where that requirement doesn't necessarily have to have been met to become a veteran. Another thing I'll mention before I get to the character of discharge is a lot of people have questions about people who serve in the reserves and in the Guard. So typically, if you're in the reserves, which is on the federal side, and the Guard on the state side, you're not going to be considered a veteran unless you get called up on active orders by the president, federal orders, basically. And so you wouldn't become a veteran until that happened. Or in the alternative, if you retired from the Guard or from the reserves, which is typically 20 years. So I do want to mention that. So one thing that we can also talk about is character of discharge. So if you're unfamiliar with it, every time that a veteran separates from the military, meaning quite simply they are exiting from the military, they're no longer going to be serving in the military, they are provided a character of discharge. So what was their service like? There are a number of different types of discharge, which are listed below. And we could talk for hours on this subject in terms of discharge characterizations, discharge upgrades. Our clinic does a very robust discharge upgrade practice as well. That's not the subject of this CLE. And then I also see Cormac here on the attendees list, who is doing them over in St. Louis at WashU. But what you can generally know is that veterans are going to be entitled to VA benefits if they have an honorable discharge. Okay. So every time that you get a discharge status that's below honorable, it may impact the veteran's benefits in some ways. It would take too long for us to go into each different option. But what you can generally know is that a veteran is going to be entitled to all benefits at the VA if they have an honorable discharge. And then they still might be available for benefits if they have a less than honorable, so a general or under honorable conditions. And then if you get to a dishonorable, veterans are not going to be entitled to benefits if they have a dishonorable. Now, something to mention on that front. That discharge characterization is going to be noted on the Veterans DD-214, and the Department of Defense makes the determination as to what that discharge status should be for that veteran. So the Department of Defense may say that a veteran should get a general under honorable conditions or something less than that. What you can do at VA is you can petition VA and say, hey, listen, that's what the DoD decided, but here's my case as to why my service actually was much better than what the DoD decided. So like I said, on the DoD side, there is a discharge upgrade process that, again, we're not talking about today. But on the VA side, which we are talking about, there is an opportunity to submit a petition to have the character of discharge for this veteran reviewed and potentially upgraded. So then they are eligible for VA benefits. So VA essentially makes their own determination on that issue. So that's something to note. We're going to be looking forward to offering different opportunities to do educational topics on discharge upgrades and things like that in the future. But if you do have questions about that in the meantime, please reach out to us. But if you have a veteran come to you, they may tell you, this was my discharge status. It was honorable or under honorable conditions. All right, moving on. We'll skip past these accreditation slides. And then I'll talk quickly about the two general disability programs that the VA has. So what I'm going to be talking to you about is the service-connected disability compensation program. So these are medical conditions that a veteran has that are directly related to their service. That's what I'm going to talk to you about in 1 minute. The pension side is just simply another program that's offered to veterans, and it's not connected to disabilities that are related to their military service. So my colleague Eugene's going to talk to you about in that a little bit, but just know that right now what we're talking about is point A, which is the service-connected disability portion. Okay, so what does it mean? Well, it's pretty straightforward. It's pretty simple. It's exactly as it sounds. It's a condition that is related to their military service. That's how you put it simply, but of course it's more complex than that. So this is the relevant statute here. It has to determine that the disability or death was incurred or aggravated during active duty service in line of duty. Now, one misconception that a lot of people have is that a condition had to have been incurred during combat. That's not the case. You don't have to be deployed and in combat and get shot or shot at in order to be eligible for benefits. You also don't have to deploy. So, even if there were some veterans who were deployed over to Afghanistan and Iraq, but maybe didn't encounter combat directly, deployment is not required in order to receive compensation. So what is required? To put it very, very straightforward, it is that something happened between the beginning date of service and the end date service to the veteran. So the DD-214 is a Department of Defense form that's given to veterans that generally is going to show their discharge characterization and also the dates that they served. So if anything happened between their start date of service and their end date of service, even if it wasn't related to their particular job in the military, then they're going to be eligible. What's the caveat to that? Well, it can't be as a result of willful and wanton misconduct. So if you get a veteran who, let's say, was on active duty, was maybe at their base, was playing basketball, and they, rolled their ankle and then caused severe, issues with their ankle, even though that's not related to whatever that person's particular job in the military was, it's still likely going to count. Now, a note about the note that says not willful or wanton misconduct. I would caution you to, whenever you hear things initially, to just assume that that's willful and wanton misconduct and therefore not applicable for service connection. The reason is because oftentimes there may be misconduct that might be related directly to the veteran service. So a prime case might be if a veteran is serving in Afghanistan and they're hit by an IED. All of a sudden they have PTSD and they come home and they're self-medicating with alcohol, and then they drink and drive and they get in trouble and they get in a wreck. Now, is that going to be a really solid case in front of the VA? Is it likely to be service connected? Probably not. It's going to be a tough case. But I just want to encourage you, to always be thinking about potential, options and the context behind that. So it is a little bit more complex than just you can't be doing something crazy. Okay. All right. So what is your basic case that you're going to have to prove in front of the VA for a condition to be service connected? So three elements. We always tell our students you can pretend like it's in torts and you're dealing with the torts elements that are hammered into your head, from the first day of torts. Here in veterans law, we have three elements here. The first one is a current disability. Do you have a current disability, or do you have symptoms of a current disability? Have you been diagnosed with something? We'll get into that a little bit more, but that's pretty straightforward. Do you have something? Okay. Now, did something happen in service, or did something get worse in service? So, okay, what was it that could have happened in service that caused this condition? Did a paratrooper jump out of a plane and they had a bad landing and they injured their knee? Or maybe they were climbing up a wall and they fell over and they, fell on their side and hit their hip. What happened in service? There has to have been something that happened for us to point to. And then the final thing is nexus, which we can just quite simply say is a connection between one and two. It's a connection between the current disability and the in-service event. Okay. So let's get into all these elements and talk about them a little bit more in depth. And we'll go ahead and do that. So before we do that, though, I do want to point out what is the standard when we are looking at whether these elements are met. So, is it that there is a nexus between the current disability and the in-service event, and it's beyond a reasonable doubt that's the case? No. So, as was already mentioned by Meg and Michaela, the standard in veterans law is as likely as not. So those of you who practice criminal law and civil law, you'll know that it's a much lesser standard than those two. As likely as not is essentially 50-50. It may have or it may have not. As long as it's as likely as not, that's what's going to be required in order to prove service connection. Now, one theory and one general thing to mention in the field of veterans law is that VA is required to provide benefit of the doubt to veteran. So that works kind of in tandem with the as likely as not standard, that let's say you have information that says it didn't happen versus it did. If it's credible on both sides, the evidence is an equipoise and the benefit of the doubt is required to be provided to the veteran. So you can see why we know that it's a very liberal standard in terms of comparison to some other areas and fields of the law. So the first one, evidence of a current disability. This seems very straightforward, but what can you do to prove this? Well, the easiest way to do it is to get medical records from the veteran, and if they have a diagnosis straight from their medical records that says this veteran has sleep apnea or this veteran has a left knee condition, that's going to satisfy this element. If they don't have medical records, a lot of my veterans often don't seek medical care for a lot of their issues that they're dealing with. They may get to just go and see a private physician, and if the physician can note that they do indeed have a condition, then that's going to satisfy the element for that. Now, we'll get into it a little bit later, but a veteran, when they file a claim, they don't initially have to prove that they have a diagnosis. They just at least have to prove that they have symptoms of something, so they are experiencing something. How can that be proven? Well, it can be proven through a statement from them, from a family member saying, you know, hey, every time that I move my knee, it hurts terribly. Well, typically that's not supposed to be the case with knees, and so that's going to evince some type of condition. And they're eventually going to be required to send a veteran to an examination to determine whether there's a diagnosis, which we'll talk about in a second. But I do want to note that when you're filing an initial claim or you're working on an appeal, you don't necessarily have to have that diagnosis. It does help. It makes you be able to meet that element immediately, but it's not necessarily required. So that's the first element. You have to have a current disability. Second element, I talked about this. Second element is an in-service occurrence or aggravation. So often what I say, like I said earlier, is something had to have happened in service. Okay. Um, what kind of evidence could we use in order to meet this element? Well, quite honestly, it's often pretty easy. An element or something we can to use to meet this element would be a statement from the veteran. Hey, I'm veteran so and so. While I was in service, I, jumped off of a big wall and I landed incorrectly, and my knee has been hurting ever since. There you go. That's evidence of an in-service occurrence. Um, Service treatment records. So if the veteran went to sick call while they were in service and there's something noted in their service treatment records, that may be something that could show an in-service occurrence. A letter to a wife or a husband while they were in service that said, hey, this just happened to me. There's a number of things that can be utilized to meet this in-service occurrence. Another element that we're going to talk about in a little bit, the nexus is a theory of meeting this element is aggravation. Or you can just note that when you were in service, you may have had a condition prior to service, but this condition got much worse. So again, that can be done through a statement, through service treatment records, whatever it might be. So that's the second element. So what is the third element? Well, the third element is, typically going to be the most important element and the hardest element to meet. And that is a nexus between one and two, like I said. So is there some type of connection between the current disability and the in-service event? So what is required to meet this element? Well, there has to be some type of medical evidence that can connect one and two. So a veteran is not competent to say, my left knee condition was caused by my fall in service. Logically, as lay people, we think that there probably seems like a connection there. But as an attorney, I'm not eligible to be able to provide a competent opinion as to whether the left knee was caused by the fall. But a medical provider can. So that's what we're going to need here, some type of medical evidence through an opinion by a physician that says, based off of my review of everything, this left knee condition was caused by the fall during service. Again, to reiterate, what is the standard here? Well, when that physician is looking at it, it's not, based off of, general medical certainty, or it's not by a preponderance of the evidence. It's as likely as not that this left knee condition was because of this fall during service. So that's the standard that you're going to be looking at. So in order to meet that final nexus, you're going to have a connection between, again, the current disability and the in-service event that has to be from a medical professional. Now, there are a number of theories that you can pursue whenever you're dealing with the nexus element. So the one that I've been describing so far has been the direct service connection. So that's very, very simple. It's just like I said, you have something that clearly happened in service, and then you have a current disability, and we are trying to directly connect that with what we're doing here. So that's very, very straightforward. Here's the relevant regulation. But again, the knee example is the best example. If it comes to mental health, a veteran may have encountered a firefight in Afghanistan or Vietnam, and now they're dealing with PTSD. That mental health condition is directly related to their service. So that's direct service connection. That's the first way that you might be able to meet this third nexus element. Okay. Now, what's the second way? Aggravation. So, aggravation is pretty much exactly what it sounds like. What aggravation is if you have a condition before you come to service. So, let's say a guy's playing high school football and he injures his left shoulder, then he joins the army. His shoulder might not be 100%, maybe it's at 95, 99%. He's still got some issues, but it's not enough to disqualify him from serving. But he still did have a shoulder issue before service. Let's say he gets into service, he's been deployed, he's carrying a big rucksack and it's 120 pounds, and he's got a gun with him and he's searching, in the hills of Afghanistan for enemy combatants. It's very unsteady and his shoulder starts to worsen because he's dealing with this huge pack. Well, after service, if his shoulder condition has indeed worsened, then he can get service connection for his shoulder. So essentially, his shoulder was aggravated by his military service. One thing to mention is that when veterans enter the service, they're going to have a medical physical. It's going to be an entrance examination. And generally, what veterans are entitled to is the presumption of soundness if nothing is noted in their entrance examination. So in that example, if the veteran had no notations for his left shoulder when he entered service, then he's presumed to be sound in terms of his shoulder. Now, the presumption is exactly what it sounds like. It's a presumption, so it can be rebutted. So if VA can show clear and unmistakable evidence that the condition did exist prior to service, even if it's not noted on his entrance exam, they can still rebut that presumption, but it's very, very hard. And so that's one thing to note, is that entrance examinations are fairly important, because if there's nothing noted on the entrance examination for a particular condition, then the veteran is going to be presumed sound in terms of that particular condition. So that's aggravation. Again, think about it through the lens that we are on the third element, the nexus element, and these are just different ways to prove that element. So another way is presumptive service connection. And let's do presumptive. So another way is presumptive service connection. Many of you have probably heard in the news recently about the PACT Act, an act signed into law by President Biden, which expanded benefits for Gulf War veterans, Vietnam veterans, Afghanistan and Iraq veterans in a huge way. And so that's an example of an act that then allowed certain conditions to be presumptive, meaning we are going to presume that your condition is related to service. So how do you meet these presumptions? Well, essentially, Congress is going to lay out particular areas in the world, like Afghanistan, and particular time periods. And then they're also going to lay out a list of disabilities and symptoms. So let's say sinusitis or rhinitis or sinus issues, breathing issues. So they've got a list of conditions, and then they've got a list of places and time periods. And what they have said is, if you are a veteran and you can prove that you served in this place during this time period, and you have this current condition, we are just going to presume that these are connected. You don't need to go out and get a nexus statement from a physician. So they are entitled to the presumption of service connection. Now, it doesn't just operate for Afghanistan and Iraq veterans. There are presumptions also for Vietnam veterans, veterans who served in certain areas that had contaminated water. And so why is this important? Well, it essentially eliminates this nexus requirement from the veteran's requirements to prove service connection. So if I have a veteran who has a condition that's on the presumptive list, and they served in the particular area and time period, then essentially I can argue VA has no leeway here, that they are presumed to be service connected for this issue. Again, like I talked about in aggravation, they are presumed to have service connection, but VA can rebut that presumption if they show clear evidence that the condition actually arose from something else besides the herbicide exposure or besides the contaminated water exposure. But typically, it's going to be a much, much easier case if your veteran's going to have this presumption that they're entitled to. So that's another way that you can meet this final nexus element. Um, let's talk about secondary service connection. So if you are a veteran who has a condition, let's say that was directly related to service, I'll use again the example that they had a left knee issue and it was directly because of a fall that they had while they were in service. And VA says, you know what, you're right. Clearly, this is because of service. We're going to service connect you for your left knee. So that's all fine and great, but now the veteran has severe pain in his left knee and he's kind of hobbling because it hurts to walk on it. And then he starts favoring his right knee, and all of a sudden his right knee gets worn down and he's got severe problems with his right knee. Well, the right knee wasn't directly caused by service, but his left knee service connected condition, it also then caused this right knee issue. So you can apply for service connection for the right knee on a secondary basis. So secondary service connection generally is going to mean a service connected condition caused another condition. Okay. So that's a direct secondary service connection. One thing I want you to realize and note as well is that there is also a secondary aggravation service connection. So let's say that the veteran had a condition prior to service, but after they got out of service, their service connected condition made it much, much worse. So you can also get service connection on a secondary basis if a service connected condition aggravated another condition. So that's something to keep in mind, is that the secondary service connection has a direct and an aggravation theory attached to it. One thing also to note is that whenever I say a service connected condition caused another condition, oftentimes veterans are entitled to service connection for residuals of a condition. So it doesn't necessarily mean that it caused another condition, but you may have residuals or symptoms of a service-connected condition. So a prime example might be diabetes. If a veteran is service-connected for diabetes, we know that it's very prevalent for people with diabetes to deal with neuropathy in their feet. So a veteran may be able to get service connection for neuropathy as secondary to the diabetes as a residual symptom. So there's a number of things that you kind of want to be keeping in mind when dealing with these things. Oftentimes, whenever I talk to my veterans and I see their file and I see that they are service connected for something like diabetes or hypothyroidism, I make sure to ask them, what symptoms are you experiencing? What other conditions could this may have caused, to make sure that you're able to pursue service connection on that basis as well. So another possibility, and this is an area our clinic does not do this, but I do just want to make you quickly aware of it, is an 1151 claim, which comes out of the relevant statute. And essentially that is some type of VA medical treatment error. So, they commit negligence whenever they're committing a surgery or providing care or something like that. There is a possibility to become service connected for that condition. So if you're in surgery at a VA medical facility and they clip a nerve or there's some type of negligence, you can apply for service connection for those issues, and they treat them as though they were service connected. So our clinic doesn't do that work, but I do want to make you aware that that is a possibility of something you can pursue. So before I talk about the claims process, I'm just going to back up right here because I want to just go back again to our elements, because you're going to feel very, very comfortable if you're working in this field and you have these elements down. So again, we have a current disability. So something's happening. You have symptoms of something. You may have been diagnosed with something. Next, is there an in-service occurrence? So did something happen in service, or did something happen in service that made a condition worse that they had before they were in service? And then finally, again, a nexus between 1 and 2. Is there some type of medical connection between the current disability and the in-service occurrence? Okay, so those are our 3 elements. And remember, when we get to that third element with nexus, so what I always teach my students is, okay, we've got element 1, we know he has a current disability, and we've got element 2, he clearly was in combat. We've got a statement from him that says that he was dealing with all these things. He was hiking up and down mountains. We've got that one. Okay. Now we just need to figure out, is there a connection between 1 and 2? Well, let's take a look at all the different options at our disposal when we're trying to meet that nexus element. Okay, so it doesn't just have to be direct, it can be all the different elements. So again, you're going to take a look at things and say, how can I get this veteran service connected if I think there's a colorable claim here? Is there a direct option? Okay, maybe what about aggravation? Did they have this condition before service and it got worse? Let's check the presumptive list. Do they have a condition that's on a presumptive list? And then did they serve in areas and time periods where Congress says they're entitled to the presumption? Or secondary, do they have a service-connected condition that might have caused this other condition or made it worse? Maybe that's an option that we can pursue. So I would encourage you, whenever you take a look at a file, to take a look at all these different possibilities for achieving nexus, because oftentimes it may be that you can argue the direct and the secondary at the same time. You can say, well, it directly happened, but assuming that VA doesn't think it did, it also very likely could have been caused by the left knee issue. And so, you're going to always take a look at the different theories of nexus that are available to you. So again, please ask questions down below. My colleagues, I think, are doing a good job of answering. I'm not seeing it, but I'm sure that they are. So let's talk about the claims process. So again, right now we are at the stage where we're determining, does this veteran have a disability? Did something happen in service? And do we think there's a connection between the two? Let's say, as the veteran's attorney, you figured that out and you said, yes, I think that that's the case. Okay, well, what's going to happen from there? So the VA receives a claim from a veteran. What they are required to do is they're required to review all the pertinent records. And if they determine that the veteran has met the required elements, generally, that there may be something there, essentially, then they have some requirements. So there's a case, McClendon v. Nicholson, that outlines the requirements that have to be met by a veteran in order for VA to start essentially engaging in their duty to assist the veteran. Generally, they're going to track with the elements of service connection, with the caveats that a veteran doesn't, again, have to prove they have a current diagnosis. They just at least need to let VA know that they're dealing with something. So, I've got severe pain in my left knee. I'm really dealing with some mental health issues, things like that. The next thing that VA is going to take a look at is there enough evidence here already or not enough evidence for us to start engaging in our duty to assist? What would be an example when VA wouldn't necessarily have to start engaging in their duty to assist? Would be if the veteran met all elements of service connection from the outset with their claim. How would you do that? Well, you get medical records from the veteran's provider that says he does have, let's say, obstructive sleep apnea. The veteran submits a statement that says, whenever I was in service, I was exposed to a lot of burn pits and other issues and things like that. And then his private provider wrote a nexus opinion that said, I've reviewed the veteran's file. I've reviewed medical literature that says, that burn pits and exposures to toxins can cause sleep apnea. Therefore, it's as likely as not that this veteran's sleep apnea is related to his service. If the veteran submits all that stuff, then VA technically doesn't need to engage in the duty to assist, and they should just grant service connection. Now, they're pretty much always going to need to send the veteran to an examination to determine how bad the condition is. But that's just an example of an instance where they may not have to. But generally, if you submit evidence that shows these general elements, VA is going to send you to an examination. And they're also going to get a medical opinion from one of their contractors where they're going to tell the provider, please take a look at this veteran, do an examination, interview them, and then tell us, do you think it's as likely as not that their condition is related to service? Again, they're supposed to take a look at, could it have been directly related? Could it be related to service on a secondary basis? They're supposed to pursue all available means of nexus. So once they get that report from the medical provider, then they take a look at things and they make a decision based on that evidence. So What is in a VA decision? What generally should be in a VA decision? Well, it's going to be the payment amount and the effective date for the claim, which we'll talk about in a little bit, if it's favorable. So what does favorable mean? That means VA says, yes, we think that this is connected to your service. An unfavorable decision might deny service connection, and so therefore there's not going to be any payment or effective date. VA is also required to tell the veteran what they concluded in the particular claim. So it would be a listing of the condition that was claimed and then what they decided. We decided not to service connect you because of these reasons. Or we decided to grant you service connection. So they're going to have to provide some type of conclusion. Next, there's going to be a listing of the evidence that's considered. So if you look at a rating decision, there's just going to be a long bullet point list of all the evidence that was considered when they made their decision. They often miss evidence. So oftentimes the evidence that we submitted, they didn't look at, and it's not included in there. So it's an important part of the decision that notes exactly what they looked at whenever they made the decision. Like I noted, they're going to make a determination and a conclusion, and then they're supposed to tell you why they made a decision. They're supposed to describe to the veteran why it was that they decided to service connect or not service connect. Next, they're supposed to include favorable findings in the rating decision. What does the favorable findings mean? So as I mentioned, you have 3 elements to get to the service connection. Now, let's say that the veteran meets the first element, they do have a current condition, and they meet the second element, there was an in-service occurrence. But maybe they don't meet the third element, that they got a medical opinion from the VA contractor, and that contractor said, no, the in-service thing and the current disability, they're not related at all. What VA is required to do under the favorable findings portion is say, we concede, essentially, is what they're doing. We favorably found that you do have a current disability, and we favorably found that something did indeed happen in service. Why are the favorable findings important? Well, whenever you are working on an appeal, VA typically can't come back and overturn a favorable finding unless they have some type of clear and unmistakable error. So if VA favorably finds that they have a current disability and something did indeed happen during service, but they deny because of nexus, of course, that's not a good decision for my veteran, but I am happy about the fact that they made those favorable findings, because then when I go to submit my appeal, I'm laser focused on the nexus element, and I note to VA, you've already favorably found that they have a current disability in an in-service event. So now all you need to worry about is nexus. And so that's what favorable findings are about. They also have to know what you need to do in order to substantiate a service connection claim. So, you didn't make the nexus element, or you didn't have a current disability. So, if you have medical records that show you have a current disability, please give them to us. That's what you need to do in order to be granted service connection. Next, they are required to tell you how to appeal a decision. So there has to be some type of notation in the rating decision that says, this is how you appeal if you disagree with our decision. So this is what a rating decision typically looks like. It's going to have a big seal from the VA. It's going to make initial decisions, and it's going to list the evidence like I noted. And then it's going to tell you, this is what we decided, this is why we decided it, and this is what you need in order to be granted service connection. So let's say that you are granted service connection. How is VA going to assign this veteran money? That's kind of what it's all about. A lot of times veterans apply for things out of a justice aspect. They want VA to, admit that this condition was caused by the military service, but oftentimes, there's going to be money associated with these things. So how is VA going to deal with that? So if you are service connected for a condition, VA has a rating code table that's in the chapter 38 of the regulations, of federal regulations, where it's going to note different conditions, and it's going to provide particular rating percentages for those conditions. So let's say that you have the condition of sleep apnea. If you have sleep apnea, VA is going to go to the sleep apnea regulation, and then they're going to determine under that regulation, how bad is the sleep apnea. So the worse that a condition gets, the higher the rating percentage, and the more money someone's going to get. So if you just have sleep apnea, you're going to get a lesser rating. But maybe you have sleep apnea and it requires you to have a CPAP machine. Well, then that's going to bump your percentage up a little bit more. Okay. Now, how does VA determine the rating percentages? So sometimes this can get confused. The determination of the rating percentage generally is that's what Congress and VA has determined, the percentage that it impacts this veteran's ability to work and earn money. Okay. So if a veteran has a 10% rating for tinnitus, VA has essentially determined that that has impacted this veteran's ability to earn money at a 10% level. But you do not have to prove that that's how much your veteran has been impacted in terms of their work. Okay. I just provide that guidance for that's what those rating percentages come from. So all you're going to have to prove is that they have a disability, and then you're going to have to show the particular symptoms for that disability. That's going to determine the rating percentage. Um, so that's what VA is going to do on that front. Here's an example of what a rating code might look like. So let's say a veteran had a finger amputation because, for whatever reason, they're service connected for it. You're going to go to the rating code and you're going to see, okay, so it was their thumb that was amputated. And okay, was it their major or their minor? Was it their primary hand or their non-dominant hand? And then at what point was it amputated? That's going to tell us, okay, what percentage is it a 40, a 30, a 20%? That's going to help us determine what rating percentages this veteran should be at. One thing I want to mention, as you can probably guess, there is not a particular rating code for every single condition. So oftentimes what you're going to have to do if your veteran has a condition that doesn't have a particular rating code or criteria, then you have to just find the most appropriate rating code that really encompasses that veteran's particular symptoms. So, there are millions and millions of conditions that people suffer from every year. VA can't really, deal with every single one in a rating code. So if there's not a rating code for the veteran's particular condition, then what they're going to have to do is just look and find a rating code that most closely approximates what that veteran is dealing with. So VA math. You may get a veteran who has a 50% rating for sleep apnea and let's say a 50% rating for another condition. You might think initially that that would evince a 100% rating. It doesn't. VA math is not like that. The higher rating you have, the harder it is to get a higher combined rating. So you can see the math here generally. So for example, you may have a 70% rating, and then if you get another 30% rating, that does not mean you have 100%. What I can tell you about the VA math is that Eugene and our staff here you're going to hear from a little bit, he does it, he can do it by hand. I don't do that. There's online calculators to do that. But just know that that might be something that you see right off the bat is a veteran may have 10% rated conditions. That does not mean that they're 100%. So VA math works a little bit differently. This is the amounts that a veteran is going to get as of 2023 every month whenever they're dealing with one of these conditions. So, for example, let's say a veteran has tinnitus, which is ringing in the ears. They were next to artillery all day, every day, and they had to take their earmuffs off because they needed to communicate. And now they've left service and they have ringing in their ears. They're service connected for tinnitus. They're going to be at a 10% rating. They're going to get about $165 a month. You can see that 100% rating, you're going to get around $3,600 with no dependents. That amount increases if you have dependents, and it's a little bit more in 2024. While it is a good amount, no one's getting rich off of VA disability compensation. So you're not going to retire off of it and buy a yacht because of this. So that's something to note. We have a couple minutes for questions if there are questions. Looks like Katie is answering this question is the combined rating. I use Hill and Potton's. There's a ton of them out there. But if you're an attorney who's just starting out, you can just Google VA rating calculator, and you can input all of those rating percentages in, and get a combined rating. One thing I'll say while I wrap up, and feel free to ask any more questions, is that everything I've told you is, first of all, at the tip of the iceberg in terms of the VA adjudicatory system. Um, it is very, very complex. Unfortunately, it's why attorneys need to be involved often in these claims. My heart always breaks whenever I get veterans who give me a rating decision from 10 years ago where VA did some particularly egregious things. And the veteran just thought, VA said it, so I assumed that was right. And then they come to me, and VA just did some terrible things. So everything I told you is how VA is supposed to operate. If a veteran submits an initial claim with a nexus letter, medical records that show current diagnosis, and a well thought out and reasons and thorough statement from the veteran describing exactly what happened. What VA is required to do, again, is grant service connection, send the veteran to an examination to figure out how bad it is, and then start paying the veteran. It very rarely works that way. VA is a huge system. It's complex. And it's really, really, unfortunate that veterans are having to deal with it, but that's just the case. David, do you see examples where you submit a fully developed claim and VA does not require a C&P examination? It can happen. Tinnitus might be a good example of, a veteran could submit a claim where they say it's fully developed and they have a notation that they have tinnitus in their medical records. They submit a statement that describes what their MOS was in service, which was their job in service, which again might be like being close to fighter aircraft or artillery. And it's possible that they could be sent to, they could submit that claim and not be sent to a C&P examination. Because tinnitus, really, if there's evidence of ringing in the ears, all you're going to need is a medical opinion. And VA can ask for medical opinions only. So they don't have to ask for the veteran to come into an examination and also get a medical opinion. They can just go ask a doctor, could you give us your medical opinion on this? So I would say there are a lot of cases where you can rate the veteran just based off the record. But in my experience, VA is pretty much always going to ask for an exam, even when it's not necessary. Sometimes they're going to send the veteran to an exam to get updated information. Also, do you often see a 0% rating when a disability is found? I would say it happens a lot. You probably hear in the news a lot about how the PACT Act really expanded benefits for veterans, which is it's definitely the case. And there's been a lot of news about how, veterans are getting service connected for conditions that are the PACT Act left and right. That is the case, but hypertension often is at 0%. Again, we could get into particular ratings. Hypertension, if it is managed by medication, is typically going to be at a 0% unless hypertension is really bad. And so there were hundreds of thousands of veterans who were service connected for hypertension as a presumptive condition, but they were all provided a 0% rating because it's hard to get a rating percentage. So hypertension is definitely one that could be the case. Before I turn it over to Martha, I just want to make the final comment that the reason that Martha's presentation is required, that our clinic is required, and that we need your help is that, again, VA is supposed to do these things, but they don't, unfortunately. And so that's where we need to come in order to situate these things for veterans and pursue the appeal options available to us when we're unable to get an initial good decision. So with that, I'll turn it over to our next presenter.
Our next presentation is on the Appeals Modernization Act and will be given by Martha Bradley Klein-Hesslink. Martha is a staff attorney in the Veterans Clinic where she represents veterans and their families before the U.S. Department of Veterans Affairs and Department of Defense. In addition to representing clients, Martha supervises law students, teaches veterans law, and manages the medical and legal partnership between the university, law school, and School of Medicine. Martha received her JD from the University of Missouri in 2021 and has worked at the Mizzou Law Veterans Clinic ever since. She is a member of the Missouri Bar Association, the U.S. Court of Appeals for Veterans Claims Bar Association, the National Organization of Veterans Advocates, and is a VA accredited attorney.
Thanks, Brittany. So as Carter said, the Veterans appeals process, or the veterans claims process, is meant to be paternalistic, non-adversarial, very veteran friendly, but sadly we see in practice that it becomes quite adversarial, and that's why this appeals system exists. I'll get into a little bit about the legacy appeals system, but mainly we'll be talking about the Appeals Modernization Act, which we call the AMA, because that is the governing law now since 2019. So the AMA became effective in February of 2019. So any rating decision that a veteran receives that is dated February 19th, 2019 or after is automatically in this AMA system. Any rating decision issued prior to February 19th of 2019 is what we call the legacy appeal system. Both the AMA and the legacy appeals system will run concurrently until all legacy appeals have either been resolved, or all of those veterans who are in the legacy appeals process will have opted in to the AMA system. That's just kind of the last note here. So any veteran who is in that legacy system has the option to stay in the legacy system or opt into the AMA. But once they opt into the AMA, regulations applicable to the legacy system no longer apply for that veteran. So why did Congress enact the Appeals Modernization Act in the first place? What was wrong with the legacy system? There were long-standing issues within the Veterans Benefits process system, primarily backlogs and inefficiencies throughout the system. So the AMA, just to summarize kind of what the AMA has done, they modernized the claims and appeals process. That's kind of a given with the name of the act. They include 3 decision review options for disagreements with benefits decisions, which is kind of the focus of this presentation, is to highlight those appeals options for veterans. The act also required improved notification of VA decisions. Carter touched on those, and I'll touch on those a little bit more, and also provides an earlier claim resolution. So the idea being that the AMA would kind of speed up this process for veterans. So Meg and Michaela showed this graphic earlier, and there's a lot of boxes, there's a lot of arrows. This is a graphic put out by the VA to veterans to help them understand their appeal options when they receive a rating decision from the VA. And I don't even know what's going on here. It's such a mess. So thankfully, we don't operate. Some claims still operate in the system, like I said, but most, I would say, have opted into this Appeals Modernization Act system, where there are much fewer boxes, much fewer arrows. It's a little bit easier to understand, but still pretty complex. So again, this process is meant to be one that veterans can navigate on their own without the help of an attorney, but it's become so complex and error-ridden that they do need the help of an attorney to kind of step in and walk alongside them through this process. So that's why we exist, and that's why we hope that some of you will feel inspired to help veterans navigate this bureaucracy. So on the left, you see the Agency of Original Jurisdiction. Some people call that the regional office. Remember, that's that bottom tier on the pyramid that Carter showed earlier. And in this AOJ side, we've got a higher level review and a supplemental claim option. That's 2 of the 3 appeal options veterans now have in this Appeals Modernization Act. On the right side, we have the Board of Veterans Appeals, and that's that second tier of the pyramid that Carter showed earlier. And we'll also talk about that in a little bit, but that's that third lane or that third option that veterans have if they decide to appeal their rating decision that they've received from the VA. Okay, so the AMA changed quite a few things, one thing being the definitions of certain words that are commonly used in this area. To start with, a claim, the definition is a written or electronic communication requesting a determination of entitlement or evidencing a belief in entitlement to a specific benefit on the proper form. I know Carter hinted at this earlier, but the VA loves their forms. It's kind of a running joke that we make in veterans law is that there's a form for everything. And there really is. I had a student in my office yesterday who's helping me prepare an appeal for a client. And I think we identified 6 different forms that he's going to have to help work with the veteran to fill out just on this one single appeal, because you need the claim form, you need the veteran's statement form. His wife and his daughter wrote statements, so there's a separate form for lay and witness statements, separate forms for specific benefits like total disability based on individual unemployability. So the list goes on and on and on. But there's a form for everything. I think it points this out here. I've heard, and I'll admit, I've only been practicing veterans law since the AMA has been enacted. So I've not worked in the legacy system a whole lot, but I've heard stories of veterans being able to write their application, write what they're trying to get service connected on a napkin, a cocktail napkin, and mail that into the VA. And that used to count for an application for disability benefits. But now the VA has a form for everything, and they do require that veterans use those appropriate forms. So there are 2 major categories of claims: initial claims and supplemental claims. To define an initial claim first, it's a bit of a circular definition. So any complete claim other than a supplemental claim for a benefit on a form prescribed by the secretary. These include claims requesting service connection for a disability or a grant of a new benefit. So if the veteran's never filed a PTSD claim, that's going to be considered an initial claim. It also includes claims for increased ratings of benefits paid based on a change or worsening in the condition. So if a veteran has already filed for PTSD, the VA acknowledged that veteran's PTSD is connected to their service and assigns maybe a 30% rating. Later on down the road, the veteran thinks that their PTSD symptoms have worsened and they might be entitled to a higher rating. So what they would do in that case, and for some reason the VA considers that an initial claim, they would need to file again for an increased rating to tell the VA, hey, I need you to look at this condition again and see if I'm entitled to maybe a 50, 70, 100% rating for this condition. Supplemental claims are any complete claim for a benefit on an application form prescribed by the secretary. We'll hear that language over and over, where an initial or supplemental claim for the same or similar benefit on the same or similar basis was previously decided. So a supplemental claim is kind of just what it sounds like. You're kind of supplementing something that's already been submitted to the VA. And we'll talk about supplemental claims in a few slides a little bit more. So a little more overlap between mine and Carter's presentations, but just to focus on how the duty to assist was changed by the AMA. He talked about how the duty to assist requires VA to help the veteran gather information like medical records, service records, and things like that. And VA must make reasonable efforts, not really sure what that means, to obtain such information. Under the AMA, VA's duty to assist is limited insofar as it is only required when a veteran files an initial claim for benefits and when a veteran files a supplemental claim. So once we get out of that AOJ, we move to the Board of Veterans Appeals, the duty to assist no longer applies. So just want to highlight that. The AMA also significantly changed the VA's decision notice requirements. This is in an effort to give clearer decision notices to veterans, to standardize the forms for decision notices so veterans can recognize important information more quickly. Before, it didn't seem like there was a very consistent or standardized way of issuing decision notices to veterans. So the new system it's very clear. I mean, once you've seen one rating decision, you've seen mostly all of them. They're very consistent. You kind of know what page to scroll to when you're looking for a certain thing. So the consistency there is really helpful to both veterans and advocates, and to getting to that information that you need quickly. They're also required to give an explanation of review options. So the 3 appeal options that I'll be talking about a little bit later in the presentation. They're required to explain those to veterans. And then a timeliness issue. Of course, these changes aim to reduce delays and ensure veterans have quick access to information, including the evidence considered in making that decision, and accessing those medical records the VA might have used. So we saw this list earlier. I'm not going to spend a ton of time going through it, but these are items the VA must include in their rating decisions. So identifying the issues, they must tell the veteran what it is they're making a decision on. A summary of evidence considered. I use this section quite a bit. I want to know what the VA was looking at when they made this decision and what they used to justify their decision. Which medical records were they looking at? Did they look at the statement that we submitted? That is very important to the claim. That would be listed on the evidence section if they considered it. So it's nice to kind of double check the VA's work there, but it also makes it easier for you to identify exactly which medical exam VA was using in making their decision. A summary of applicable laws and regulations. We've talked a lot about the errors that VA makes, so you always want to double check these and make sure they've used the proper laws and regulations. Identification of favorable findings. I'll talk about these a little bit on the next slide, so I'll move on for now. For denied claims, an identification of the elements not satisfied leading to the denial. So really laying out for the veteran, here's what you're missing, and here's what you need to prove in order to get service connection. If applicable, identification of criteria to grant service connection or the next higher rating. I think this is a great addition to decision notices, especially for veterans who are not represented, because it tells them exactly what they need to prove or show in order to get service connection or the next higher rating. So I don't know if the slide with the decision earlier was a little fast, but if you want to reference back to the materials and take a look there, it lays out, tells the veteran, hey, we gave you a 30% for your mental health condition because you showed these 5 symptoms, and I'm just guessing what it says. And then the next section says, in order to receive a 50% rating for this condition, you must exhibit these symptoms, and it shows a list. So that's helpful because veterans can look at that and say, well, I do have these symptoms underneath this 50%, which gives them kind of an idea of what they need to show when they appeal that decision. An explanation of how to obtain and access evidence. I kind of mentioned that. And then a summary of further review options. I discussed that as well. So all of these things need to be in every rating decision, and the VA does a decent job of that. I think one thing they tend to leave off is favorable findings, which is troubling at times. But to define a favorable finding, it's any finding favorable to the claimant made by either VA or BVA. It's binding on all subsequent adjudicators unless rebutted by evidence that identifies a clear and unmistakable error in the favorable finding. So even if a claim is not fully granted, favorable findings can help strengthen the veteran's position in future claims or appeals. So like Carter said, VA already said you have the current disability and the in-service occurrence, but maybe they didn't list the nexus under the favorable findings. So on that veteran's appeal, they can say, you've already admitted that I have the current disability. You've already admitted that I had the in-service occurrence. So all we need to talk about now and all we need to kind of flesh out is that nexus. So the veteran or the VA cannot go back on those favorable findings, of course, unless they rebut the presumption. A finding is defined as a conclusion either on a question of fact or on an application of law to facts made by an adjudicator concerning the issues under review. So now we can kind of dig into what these options on appeal are. And there are three options, as I highlighted earlier. The first two being within that regional office, and then the third one kind of jumping up a tier to the BVA. So we have a higher level review, a supplemental claim, or an appeal directly to the board. And this is just showing this is exactly what VA includes in their rating decisions to veterans. This is how they explain a veteran's appeal options, which I think is pretty clear. It lays out kind of a timeline for veterans, a QR code to access the fillable PDF forms, and it also lays out which appellate option they can use after they've already used one. So one thing I don't know that we've mentioned is a veteran has 1 year to appeal a rating decision, 1 calendar year from the date on that decision notice. So the veteran might file a supplemental claim within that 1 year. They might have new evidence. And again, I'll talk about that shortly. But the VA might still get it wrong. But say the veteran wants to then pursue a higher level review. They can do that. What if the VA gets it wrong after an HLR? Well, unfortunately, you can't do a higher level review of a higher level review. So your options down here are limited. You can go back to a supplemental claim or jump to a board appeal. So I wish they explained that a little bit better for veterans down here, because they might think, well, what the heck? Why can't I do another HLR? So it's a little bit unclear here, but just know that that is a rule to be mindful of, because VA will kick it back. And if you're outside of the 1 year, you might have issue saying that you've continuously prosecuted the claim. So what's a higher level review? This is a de novo review based on evidence before the Veterans Administration at the time of the original decision. At an HLR, you are not allowed to submit new evidence at all. The decision must also indicate if any evidence was not considered and how it can be considered on further review. So say something did make its way into the claims file after that time of that original decision, they'll let you know that they were not able to consider whatever that may have been. One thing that our office likes to do is submit a memo with our HLRs. I think it's really more for internal use, because we have so many clients and the VA will call you. You just never know when they'll call to do this informal conference that I'll talk about shortly to discuss this HLR. It's nice to have something you can reference really quickly and say, okay, these are my arguments. Some people are a little bit worried that the VA will consider a memo that you might submit with an HLR as new evidence, but we've never really faced that issue because we're not submitting any new evidence. We're really just laying out what our arguments are, what we think the errors are with the previous rating decision. So what I mentioned is this optional informal conference. So when you file an HLR, there's a box you can check to state that you would like an informal conference with the higher level adjudicator. Like I said, these are very informal and they last anywhere from 5 to 15 minutes. And you hop on the phone with a more experienced adjudicator at the VA and you really just talk through the issues. So it's not intimidating. It's not like a hearing or anything like that. It's really just a conversation with someone at VA who you can talk to about what's going on, and they'll understand exactly what's going on in the file. Like I said, it's a more experienced adjudicator who did not participate in the prior decision. So that's helpful because there's no biases or anything like that going into their review. It's a complete de novo review by someone new. HLRs apply to any and all claims under the modernized review system, except simultaneously contested claims. So once you opt into the system, you have this option to file a higher level review. If you're still in the legacy system, this isn't one of your appellate options. The request must be made on a form prescribed by the secretary. At the end of the presentation, I've got all of the form numbers for these options. But again, we have a form that the secretary likes and requires for us to use. And the higher level review must be received within 1 year of the date of the decision notice from that most recent rating decision on that issue. So the next lane, I call them lanes a lot. There's of the 3 lanes, the second one I talk about is the supplemental claim. When you file a supplemental claim, and you want to use this when you've got new evidence that might help your claim. Maybe the VA said you don't have a current disability, so maybe you go out and get some new medical records or submit new medical records that the VA has never seen that shows that in fact the veteran does have a disability. So this is a good option to choose if you feel like there's something that you can add to the file. I defined it earlier, so I won't talk through this again, but I want to flesh out a little bit more what new and relevant evidence means. New means not previously part of the record or not previously part of the VA claims file. And relevant means that it tends to prove or disprove a matter at issue in a claim. The Veterans Benefits Manual talks about how new and relevant is a very low bar. So you can submit a new theory of entitlement. So if the first submission that you made, you were claiming direct service connection, well, maybe there's been something added to the presumptive list, or maybe it's not on the presumptive list, but you think you didn't, or it wasn't on the list and now it is, or you just want to change your theory. Maybe you've discovered there's a secondary theory you can pursue. Even raising a new theory could be considered new and relevant evidence. A lot of times what we'll do is submit a new medical opinion. Maybe we've worked with a medical student at Mizzou who found a really good research article that connects PTSD and sleep apnea. You might submit that as your new and relevant evidence. Or maybe you didn't get a statement from the veteran's spouse on your first application, and they might have a lot to say and weigh in, particularly on a veteran's mental health condition. You can get a new statement from the spouse of the veteran and submit that. So options are pretty endless when it comes to new and relevant evidence. Like I said, the AMA was implemented in 2019, so we're coming up on 6 years. It's still a really young act, right? So these things haven't really been defined or litigated heavily by the courts yet. Many of these topics within the AMA are currently being heavily litigated. So hopefully we'll have more guidance from the courts on what new and relevant really means. But for now, we know that it's a pretty low bar, which is really great as an advocate. You get to be really creative in what you submit. So we talked about HLRs and we talked about supplemental claims. Now we'll move into appealing to the Board of Veterans Appeals, so jumping up one step in that pyramid. Appellate review at the BVA shall be initiated by filing a notice of disagreement on a form prescribed by the Secretary. It must identify the specific decision and issue or issues with which the claimant disagrees, and a notice of disagreement must indicate the type of review requested. So there are 3 types of review at the BVA: direct review, hearing, and evidence only. So At the direct review, there's no new evidence and there's no hearing. A decision will be based on evidence in the file. And the BVA states the goal for these decisions is about 365 days. If you work in veterans law, you know there are extreme backlogs at the BVA. So we're seeing more like 3 to 5 years for claims at the BVA, more so with these hearing and evidence lanes. So the hearing lane, the BVA will consider evidence of record at the time of agency decision, evidence submitted at a hearing, and evidence submitted within 90 days of that hearing. So plenty of opportunity to get new evidence in front of the board. Evidence only lane, the BVA will consider evidence of record at the time of the agency decision and evidence submitted with a notice of disagreement or within 90 days of filing the NOD. So you could kind of draw similarities between the options at the board and the options we talked about at the AOJ earlier, the supplemental claim and the HLR, and whether you can submit new evidence, what they will consider. But again, these are up one tier in that pyramid at the BVA. So what if you get a rating decision that denies service connection for PTSD and denies service connection for a knee condition, and you can't choose one lane for both? Maybe those denials don't quite fit in the same lane. You can separate those issues. Just because they're on one rating decision doesn't mean you have to appeal the entire rating decision through one of the 3 lanes. You can separate those out, which is nice. That you have several options when it comes to appealing. The example here is if a decision adjudicates 2 conditions, a knee and an ankle, those are separate issues that can be taken into separate review lanes, just like I was saying with the other 2 conditions. However, different review options may not be selected for specific components of a knee disability claim. So you can't take the current disability issue and the in-service occurrence issue into separate appellate lanes. That just gets a little bit too granular and in the weeds. So you need to take that condition as itself and choose a lane. So if you pick a lane, if you pick a supplemental claim, and maybe you pick an HLR, sorry, I'll back up. You pick an HLR, but then new evidence presents itself. Maybe the veteran says, hey, I got a new diagnosis from my private physician. So when you know that when you go to the HLR, you can't take new and relevant evidence. So this appeal now fits more in the supplemental claim lane. So you can withdraw a request for consideration of an HLR or supplemental claim and change review options as long as you're still within the 1-year timeline that you have from that initial rating decision. A claimant may change review options to a supplemental claim after expiration of 1 year if the VA grants an extension for good cause and the supplemental claim application is received within that extension period. So there's a little bit of leeway here if you feel like you've maybe picked the wrong lane or new evidence presents itself and you want to switch things up for your client. Thankfully, there are some ways that you can do that. I think this is my last slide, so we might be finishing up a little bit early, but we'll have plenty of time for questions. These are just the forms. I said many times a form prescribed by the secretary. And these are just the forms for those 3 appellate lanes that I was discussing. But of course, there are many, many more. But just take note of these. They're very easy to find on Google through the VA's website to find the fillable PDFs. But they do require the use of these forms, and they will kick claims back to you if you don't use the right form. So we always want to make sure people have these form numbers handy. And like I said, I think we've said multiple times throughout the presentation, because the CLE fits within what the VA requires for CLE accreditation requirements, we're really just giving a bird's eye view of these benefits and these appellate options, just so you kind of have a jump start in knowing what options are available to your veteran clients. But of course, there are many nuances and carve-outs within all of these. So just keep those in mind, but at least this gives a little bit of a jump start to that understanding. So I assume there have been some questions. But if there are any more, feel free to add those into the Q&A. And if you think of questions after the CLE, you have Kate Albers' email, and she can kind of direct those questions to the appropriate person. Can a 21-526 EZ count as an intent to file? That's a good question. I'm wondering if any of my colleagues want to jump in and type their answer. I don't, oh, looks like she answered. No. So that was my initial thought too. I think that there are arguments to be made that a 526 EZ could count as an ITF. And for those who don't know what an ITF is, it's an intent to file form. So a veteran who thinks they might have a claim for service connection, but isn't quite ready to file that claim. Maybe they need to develop some evidence. They want to speak to a service officer or an attorney. What they can do is either call in or submit what's called an intent to file form. And that kind of holds their place in line. They get 1 year from the date that they submitted the intent to file or called in the intent to file to submit a claim, a 1 calendar year. So it just gives them extra time to develop their claim. And if that claim is granted, the VA will pay them back to the date that they submitted the intent to file. So that's what I mean when I say it holds their place in line. That's kind of the start point for the veteran, as long as they've filed that claim within a year.
So technically it can't serve as an intent to file, but you could file an initial claim, and if it wasn't correctly filled out for some reason, then there are some regulations that requires VA to provide notice to the veteran on how to correct the claim to preserve the effective date. I don't know off the top of my head what that is, but I don't think I'd have to look that up. But generally, it's not going to, like Katie said, it's not going to serve as an intent to file. But it does happen when veterans file a claim and then forget to sign it, or don't put their name on it, or something like that. That there are potential ways to correct the claim and preserve the effective date. Katie might have some thoughts on that, but.
Another question from Sherry says, under the AMA, what is the earliest you can file for the attorney fee agreement? That's a good question as well. The Veterans Clinic does not have attorney fee agreements. All our work is pro bono. So I don't know the answer off the top of my head. I see Carter is typing. If he doesn't know the answer, Sherry, we can get that information to you, but I just don't know it off the top of my head, as we don't have those. Do you typically start representing veterans at the initial claims filing stage or at later steps in the process? Thanks, Scott. So the Missouri Veterans Commission is an entity in the state that is funded primarily to help veterans file their initial claims. We don't typically do those. If a veteran comes to us and they've never filed before, we'll probably send them to the Missouri Veterans Commission just because they're uniquely situated to help with those initial claims. And we are funded with the understanding that we will help veterans through this really complicated appeals system.
Martha, I'll type this in the chat too, but in response to Sherry's question, typically it's going to be after the initial claim is filed and a decision has been made. So once it's in an appellate stage where you have to appeal it, but you cannot charge for assisting veterans with initial claims.
Link asks, what's the best way for attorneys to file documents with the VA? He's used e-benefits for a veteran and was able to see all previously filed documents. A spouse I represent does not have an online account. I'd like to see docs previously submitted. So we file documents with the VA by using Quick Submit. You have like an ID Me account through the government that allows you to log in, and you can file documents for any veteran that way. Then we have what's called VBMS, and I'm not positive what that stands for off the top of my head, but essentially it's a VA system that holds all of the VA claims file for that veteran. And you do have to have a 2122A in place with that veteran to access their file and see all of the previous filings. You can get a 2122A and designate kind of that spouse, and VA should give you access to the deceased veteran's file, and you can still see everything that relates to that veteran's claims and that spouse's claims. VBMS access can be kind of like pulling teeth, getting the VA to give that to you. I think mine took about 13 months. Someone said Veterans Benefits Management System. Yes, thank you for that. So it's worth pursuing for sure. VBMS, I mean, it's a godsend. We're on it every day, constantly checking in on our files because we don't want to wait for the VA to mail us decision letters. We want to see those as soon as they come down. So that's what we use. I highly recommend doing the same. I have found VBMS access to be very hard to obtain. That's what Meg's saying. And then now that I have it, it doesn't even work for me, so I've not been able to use it. Yeah, it can be a real pain. Like I said, it took me 13 months to finally get access to VBMS. What we do is email I think they're called the change management agent at our local VA, and he can typically put us in contact with someone to remedy issues that we have with VBMS. So if you just hop online and look for a list of all of the change management agents, I think I'm saying that right. I know they're a CMA is what their title is. You should be able to email the CMA for your state or the closest regional office to you, and maybe they can help you out. Any other questions? Is MU Law a nonprofit that helps veterans for free? Yes, we are a nonprofit. We don't charge veterans anything for our services. And if you're an attorney, you know, obviously, I mean, everyone knows that attorneys cost quite a bit of money. And so we're very pleased to be able to offer free legal services to veterans. And we are able to also provide we pay for veterans to get private medical opinions at times. And all of this is because we have very generous donors who help fund our efforts here at the clinic. So for those that don't know, we do get a portion of our budget paid for by the Missouri General Assembly, but the rest is all soft dollars. So we rely heavily on donations, and we're very grateful for those who give to the Veterans Clinic because it just helps us help more veterans. We'll give it a couple more minutes. Okay, I'm gonna hop off and post the name and address for donations again, please. I will speak with Kate, who's organizing the event, and see if she can maybe include the link to our donate tab on our website. Or feel free to Google our website yourself, and there's a tab to donate to the Veterans Clinic, and we certainly appreciate you asking that question. Can you do this work purely remotely, or is there an expectation that you meet with veterans in person? I think that's probably a personal preference. Like Carter stated, he works remotely from Washington, D.C. He, I know, is very actively communicating with his clients on the phone. And anytime he's back in Missouri visiting the clinic, he's making efforts to meet with clients. Many clients don't seem to mind. I will let Carter kind of speak to that if he wants to jump in. But no, there's no expectation that you meet with veterans in person. Sometimes it's easier because some of these forms do require wet signatures, which can be kind of frustrating. But yeah, other than that, I think that it can be done purely remotely, and many veterans advocates do practice remotely. If a veteran is denied and within the calendar year submits an intent to file and later a supplemental claim, and the case is later granted, will the back pay date be from the intent to file date or the denial date? I think I'm reading this correctly, but correct me if I'm wrong. If you're submitting the intent to file within the year, many advocates are saying that these days that constitutes continuous pursuit. So you would keep the original effective date. So I don't think it would be back to the intent to file or the denial date. It would go back to that original application. I personally, as an advocate, get a little nervous submitting an intent to file when I plan to submit an intent to file later. I hear that you can do that, but again, I just get a little nervous that I'm going to break that chain. So I would just personally probably recommend filing the supplemental claim instead of the ITF. But to answer your question, I think most are saying that's continuous pursuit these days, so it would go back to that initial filing. Bridget says, I'm a paralegal for a nonprofit legal service, want to become VA accredited agent. Should I submit my application early, even though I'm not ready to take the test yet? Maybe Eugene O'Loughlin can type an answer to you, Bridget. I'm not as familiar with the application process for an accredited agent and how quickly that moves. I know sometimes the application process can take 1 month, 3 months, 6 months. So depending on how slow the VA goes, it might give you enough time to prepare for that test. But yeah, maybe Eugene, I see him typing. He can give you a little bit of guidance there. Is there an option to print the materials and charts that were discussed during this webinar? So the PowerPoint's posted to our website. I believe a link was shared earlier. I think that question disappeared.
Yeah, we'll get the link to the PowerPoint and the recording and the program and everything else. It'll be in the email that gets sent to everyone after the CLE.
Right. The charts, I'm not positive. If there's something specific you're looking for, let us know. Maybe we can send you a link to wherever we hold those charts because they might be screenshots that we've put into our presentation.
Luis, one thing I'll quickly say in addition to what Martha said, I think there's a case that came out that was titled like military advocates something at the court recently, I think, regarding the issue you're talking about, that I think does say that if you get a decision, file an intent to file, and then file a supplemental claim, more than a year after, that technically that might preserve your effective date. I will tell you there's like a 99% chance the regional office will not get that correct. And so the new and relevant standard for the supplemental claim is such a low threshold that if I were you, I would file a supplemental instead. And then if you needed to eventually get evidence that was going to be determinative, you could then submit it as part of another supplemental. So it's a difference between what you technically can do and what VA is going to approve. It would take you maybe 3 years to appeal a decision to get the correct effective date on that issue. So just keep that in mind.
Looks like all of the questions have been addressed in the Q&A. So I'll go ahead and hop off. And I believe Michael Smith, one of our Veterans Clinic students this semester, will be introducing the next speaker. Thank you.
Good morning, everybody. I have the pleasure of introducing the next two speakers, Eugene O'Loughlin and Katie Becker. Starting with Eugene. Eugene is the intake coordinator with the Veterans Benefits Specialist in the Veterans Clinic. He comes to the Veterans Clinic with 14 years experience as an accredited Veterans Service Officer with the Missouri Veterans Commission, where he has assisted tens of thousands of veterans with their claims for benefits. Eugene served in the U.S. Army from 1985 to 1988 as a cavalry scout, where he was stationed in Germany, and from 1988 to 1993 as a heavy equipment operator in the Army Reserves. He has fond memories of his military service, and it's a large motivator for him to assist his brothers and sisters in arms. Eugene works tirelessly and continues to go far beyond the normal duties of a veteran service officer. In recognition of this, he received the 2024 Liberty Bell Award conferred by the Young Lawyers section of the Missouri Bar. The Liberty Bell Award is given to a non-lawyer in Missouri for exceptional public service that enhances the legal community or advances justice. Eugene's passion for assisting veterans and helping train the next generation of veterans advocates is truly incredible. Katie Becker is the newest staff attorney to join the Veterans Clinic at the University of Missouri School of Law. In this role, she supervises students and manages an active caseload, assisting veterans and their dependents with obtaining benefits they have earned through service to our country, primarily before the U.S. Department of Veterans Affairs and the Department of Defense. She previously served as the staff attorney for the Veterans Legal Clinic at the University of Georgia School of Law and as an associate appellate attorney with Chisholm and Kilpatrick in Providence, Rhode Island. She also interned with the Veterans Consortium Pro Bono program in Washington, D.C. She earned her law degree magna cum laude from Syracuse University College of Law, where she served as an executive editor of the Syracuse Law Review, was inducted into the Order of the Coif, and served for 4 semesters as a student attorney in the school's Veteran Legal Clinic. Thank you.
All right, good morning, everyone. Thank you, Michael, for that introduction. I'm going to be discussing the non-service connected disability pension and the survivor's pension. Now, these are another program that the VA has that could provide some financial assistance in the event of a veteran or their surviving spouse being in need. This is an income and a net worth-based program that is eligible for wartime veterans only. Much like the disability compensation benefit that is comprised of 3 components, so is the pension, the disability pension and the survivor's pension. And those basically are that they need to have wartime service, that they meet the income criteria, and they meet the net worth threshold. So the non-service connected disability pension is also is also known as the live pension, and the survivor's pension has previously been called the death pension. That was a couple of years ago. So I mentioned that the 3 components, the very first thing is that they have to be a wartime veteran. Now, it's also based on a disability because it is a non-service connected disability. So the VA states that they have to have a disability that prevents them from working. For pension purposes, being over the age of 65, it qualifies as a disability for these purposes. If they're under the age of 65, they have to have some kind of diagnosis that is severe enough to prevent them from working. The pension itself is comprised of there's a basic rate, there's a housebound rate, and an aid and attendance rate. Now, the aid and attendance program, a lot of people talk about the aid and attendance program. That is a component of the non-service connected disability pension and the survivor's pension. These are disabilities that are based on not being related to service, so age or an automobile accident that occurs afterwards that prevents them from working, or just basic diagnoses that prevent them from working. So the non-service connected disability pension benefits available to veterans, surviving spouses, or dependent children. And this could apply to adult children that are deemed dependent still, that were deemed incapable of self-support prior to the age of 18. So the active duty minimum criteria. Prior to 1980, an enlisted veteran, needed to serve at least 90 days on active duty other than for training. And for an officer after 1981, or prior to 1981, they would have needed to serve at least 90 days on active duty other than for training. After those dates, they would have had to have served 24 consecutive months on active duty, unless in the event of a National Guardsman or a reservist that was activated for less time than that, as long as they were activated and deployed for the entire time that their unit was, barring coming home for based on a medical, emergency medical care treatment, then even if they only served for 3 or 4 months, that could be sufficient to meet this criteria and bypass that 24 consecutive months. If they were activated for the entire time that their unit was activated, and they only need to have served 1 day during a wartime period. So prior to 1980 or 81, if they're an officer, they need 90 days on active duty other than for training. After that time period, 24 consecutive months, or the entire time that their unit was activated if they were a reservist or National Guardsman, but only 1 day has to have been served during a wartime period. They did not have to have served in combat. They could have never left the United States during that time period. But as long as they meet those criteria, they are considered an active duty wartime veteran. And this program is set up for those with an honorable or a general discharge. If they have a less than honorable, other than honorable type of a discharge, they're not going to qualify for this. Again, it is a disability-based program. So if the veteran is at least 65 years old, they have a permanent and total disability, they're in a nursing home. There's a reason why they're in a nursing home. Obviously, they cannot work. Okay. They're getting SSDI. So the active duty requirements, I don't know what's going on with my slides. I apologize for that. So there's the wartime service. Net worth guidelines. Here's where this very, very simple program, because you need to be a wartime veteran with less than a certain amount of net worth, with trying to live on a certain, less than a certain income, and obviously have a disability that prevents you from working, begins to get very complicated. Because when the VA is looking at net worth guidelines, they're not going to count your home. They're not going to count an automobile, your furniture, your clothing. They're not going to count the stuff that you use every day. What they are going to count is the money that has been set aside for the future. It's the stuff in the checking, savings, CDs, stocks, bonds, mutual funds, annuities, trust account, farmland, second homes, vacation properties. They're not going to count the tent that you own, but they are going to count that $250,000 RV. That's the net worth that they're really looking into. Aside from that, they're also going to count the previous calendar year's income, but they're going to subtract the previous calendar year's medical expenses. So it tends to offset somewhat, depending upon what your medical expenses have been. This is this is a great program to help delay the need for Medicaid. Okay, for Medicaid, you need to be basically destitute. For this program, you don't have to be destitute, but over time, if you're going to use up all your net worth, this is a great way to slow down how fast you're using that net worth. There is a look back. Again, this program gets very complicated very quickly because you can't give away your net worth in order to receive a federal benefit. Okay, it doesn't work that way for Medicaid. It doesn't work that way for the VA. Medicaid has a 5-year look back. VA has a 3-year look back. So there is the penalties. There's a penalty that can be applied in the event that you do pass along your net worth, or your client passes along their net worth to their children. If that net worth is less than the $155,000 guideline with the income and the medical expenses from the previous year, keeping it less than that, they would still qualify. So, but that money is still going to be counted as net worth. If it's above that, and they in turn pass along some of that net worth to help them fall below this threshold, the VA is going to penalize that money, and they're going to not allow the VA is not going to award the pension or the death pension until the amount of money that you would have received at the maximum rate for the income gets basically repaid. So if in a nutshell, if you're going to pass along money to your children, do it before the 3 years is up. You know what I mean? You want to give it away, and then don't apply for this for 3 years, because they're gonna hold it back. So again, that's what a lot of these slides are getting into. Calculating the penalty period. Again, it's an explanation here. It's a little complicated, but in a nutshell, it maxes out at 3 years. So if you give away $1 million to your children, okay, wait 3 years before you apply for this benefit, because then you'd be eligible for it. So the third leg of this is the income thresholds. And again, I've already kind of compared this to like the Medicaid program, and it is it's a minimum needs based program. Don't know what's going on with my slides. I don't know if Katie's controlling the slides or. Okay, thanks, it's back. Okay, so I've provided the 2024, my apologies, I updated the numbers, I didn't update the year. Pretty typical for me. But the annual, this is the threshold. This is the minimum amount of money that this is the minimum amount of money that the VA says that a veteran should live on a month. A single veteran that has no dependents, okay? The annual amount that they should live on, or the monthly amount. I learned these on the monthly amount, so I'm going to use that as the guideline. So the VA says the minimum they should live on a month is the $1,379 per month. So in the event that they have, $1,000 a month coming in from Social Security because they're 67 years old and that's the only income they have, under these programs, the threshold is the $1,379.25. They have $1,000 a month coming in from Social Security. So the VA, in essence, is going to give them about $379 a month to get them back up to this threshold. All right. In the event that they meet the housebound criteria, which basically means that a doctor says that they're unable to leave their home without some kind of assistance. Maybe they have trouble standing at the stove long enough to cook bacon and eggs, that kind of thing. That income threshold, as you notice, goes up a little bit because it costs that person a little bit more. So the money that they may be paying someone to drive them back and forth to the doctor's appointments or to church or whatever it may be, could be counted to offset their income. And then those that have the aid and attendance, that meet the aid and attendance requirements, are people that need assistance with all of their activities of daily living. So they need assistance with meal preparation, medication management, personal hygiene needs, transportation, ambulating, dressing and undressing. Those are your folks that are residing in an assisted living facility or a nursing home, or even getting that care at their home. The VA says that a single veteran in that situation should live on no less than $2,300 a month and change. So that same veteran that's getting $1,000 a month in Social Security, and that's their only income, that needs to go into a nursing home. In that situation, they're probably paying $5,000 a month or more for the nursing home or the assisted living facility. In that situation, they have $1,000 coming in. The VA is going to reduce that income by the $5,000 they're paying for that assisted living facility, dropping them below zero. The VA starts this benefit at zero, and they would increase it to the $2,300 a month. So they would award them $2,300 a month in that situation. They have 1,000 coming in from Social Security. They've got 2,300 coming in from the VA. They've got $3,300 a month to pay that $5,000 a month assisted living facility fee. So they're pulling roughly $1,700 a month out of their net worth, as opposed to pulling out $4,000 a month. Because if they only have $1,000 coming in, again, this could provide them with $2,300 a month. So the VA there is slowing down how fast they're using their net worth so that it lasts a longer time. The VA says everyone should pay a portion of their own medical expenses. So like on the last slide, I gave you the example of the VA with that gentleman, with that veteran that gets $1,000 a month from Social Security. The VA would give them approximately $379 a month. Well, they really wouldn't, because they say everyone should pay some of their own medical expenses. So in that situation, the VA would say a single veteran would have to pay $827 a year towards their medical expenses. And that works out to be about, that would be somewhere in the neighborhood of about $80 a month, $75 a month. So they, in that example, the VA would give them about $304 a month. Again, just doing the math in my head quickly. So there's a MAPR rate for a surviving spouse, one for a veteran, and for a couple, a married veteran. In the event that you do have a married veteran, okay, there's increased thresholds for those veterans that, we've got a veteran and spouse. You have two incomes coming in, but it costs more to live. So the VA increases those amounts to $1,800 a month for a married veteran. Where the veteran requires the housebound care, it would increase to $2,100 and change. And in the event that the veteran meets the aid and attendance level of care, it increases to $2,727 a month. In the event that it's the spouse that requires that housebound care or the aid and attendance level of care, the threshold the VA would use would still be the $1,800 a month, but the medical expenses it costs to care for that spouse would be used to offset their income, reducing that income, further down, providing them with a greater benefit. Confined to their residence, but still able to leave with assistance. Okay. So the aid and attendance, and again, a lot of people know this program as the aid and attendance program. It is one component to the non-service connected disability pension or the survivor's pension program. But the aid and attendance level of care is those people that need assistance with all of their activities of daily living. They're residing in an assisted living facility. They're living in a nursing home. uh, stuff like that. So the additional benefit that a doctor would have to complete the VA Form 21-2680. There are applications that would still need to be submitted for the pension benefit that I get into in a minute, or the survivor's pension. I list the form number there as well, but this is the form that would be required to be completed by a doctor, to where the VA would say that they meet the housebound or the aid in attendance level of care. Like I've mentioned a couple of times, there's medical expenses that can be used to offset their income. So in the event that they're paying a premium for Medicare, or they have a premium for a supplement, what the VA is going to use at the beginning of the year to project what the estimated benefit is going to be, they're only going to count the regular and reoccurring predictable medical expenses. So the co-payments that you're counting, that you pay for medications and stuff like that, are not going to be counted as a medical expense in the beginning of the year, but they can be counted at the end of the year when you do like a recap, kind of like your taxes at the end of the year. So again, medical expenses, that assisted living facility, that nursing home cost is going to be a medical expense used to offset your income. Listing more medical expenses. At the end of the year, a medical expense report must be completed, because at the beginning of the year, you're sending in the application with the doctor's form, the 2680, and a list of regular, recurring, and predictable medical expenses. But at the end of the year, you have to submit a medical expense report that basically says, yes, I paid all these expenses and I paid these others as well, which can amount to another additional check if you're not getting the full maximum benefit. The medical expense report number 8416. So applying for the non-service connected disability pension, you would use the 21-526EZ basic form for the VA, fill in all the boxes. So for the survivor's pension, you'll notice that monthly threshold is considerably less than that for the veteran. But it is the Department of Veterans Affairs, not the Department of Veterans Spouses Affairs. So, but the program works exactly the same way. The veteran still had to have been a wartime veteran, meeting the criteria for honorable service, active duty. The surviving spouse has to have net worth below that $155,000 and change. The income has to fall below that 925 if they're capable of living on their own, or if they're housebound, it goes up. And again, it goes up as well in the event of the need for the aid and attendance level of care. So got some examples. I mean, there's your single veteran who has the inability to work, and they haven't been awarded Social Security disability. The VA could provide them with $1,379.25 a month. The same veteran then gets granted the $1,000 a month. The VA would reduce that amount down to the 704, 705, whatever it would be, close to that. A single housebound veteran living on $1,400 a month in Social Security pays $600 a month for assistance in transportation costs. So the VA in that situation reduces that $1,400 in Social Security down to by $600. The VA would give them about $885 a month to get them back up to that $1,400. That would be a $1,478 benefit. Then the surviving spouse, same thing. Couple of good examples to rely on. Again, it's a simple program that gets very complicated very quickly, but it's not hard. Once you know the basic guidelines, non-service connected disability pension, wartime service, net worth below a certain threshold, and that goes up every year by the COLA, as does the income thresholds. VA follows the Social Security COLA increase. So I think I got more examples for you to refer to in the event that you want to look at some of those. Think I'm going to be wrapping it up and turning it over to Katie Becker now for the dependent and indemnity compensation portion. Thank you.
Thanks, Eugene. Just to say good afternoon, everybody, or close to it at this point. I'm going to apologize and bring the mood way down because here we are pretty much talking about death and compensation. Unlike most of this morning's presentation where we were talking about benefits awarded directly to veterans, DIC, or dependency and indemnity compensation, is really a benefit that goes more towards the veterans survivors. So let's start getting into it. Just definitionally, we're going to be covering a lot of ground pretty quickly, and I'm hoping that this for you is a little more of an issue spotting exercise. For the folks who care to know, generally the rules governing DIC, because it is such a narrow kind of topic, are found in 38 USC 1310 through 1318. That's the governing statute. And then by regulation, 38 CFR 3.312. So those are going to be kind of your source. And of course, there's a lot of case law at the Court of Appeals for veterans claims in the federal circuit about these issues. So just to put that out there. Fundamentally, what this is a monthly tax-free benefit that's paid by the VA to a veteran survivor. Now, there are the issue of who is eligible, who is an eligible survivor is one that we'll get into before we get into the substance of what they would need to prove, which is that the service member or veteran passed away as a result of either a discretely service-connected condition or their military service as a whole. So we'll have a lot of discussion about that. What I have here on these slides are just some of the baseline definitions. So these are going to sound very familiar to what Carter covered earlier today. And that is because in many ways, the analysis for DIC really overlaps with the analysis for service connection. Although arguably it's a little bit broader, and we'll talk about that as we go. So now that we have our definitions down, let's start with focusing on the people who would be eligible to request DIC from the VA. First and foremost, and I would say the vast majority of cases that I've handled have been the surviving spouse who comes to the clinic, who comes to the organization and asks for benefits. Surviving spouse, here's our definition from Congress, which is, as you can tell, quite convoluted. I will say in my experience, primarily the fight is over whether the veteran's cause of death was related to their military service and less about the eligibility of the spouse. But I think it's worth flagging that this could be an area where you could have a fight. And you should be able to, I suspect, in getting the story from the surviving spouse, have a sense of how complicated is this family's kind of history. This is pretty much as close as VA gets to doing family law here. So there's a couple of component parts worth noting, just parsing through this definition. Same-sex surviving spouses can receive DIC, and that's been true since Windsor. VA has chosen not to litigate that particular issue. They've said it's a non-issue. So just to confirm, that's a possibility. But generally, it's going to be a spouse of a veteran. They were married at the time of the veteran's death and who lived continuously from the date of marriage to the date of their death. That doesn't mean that they've spent every day together, but just to say that there was no kind of clear break in that marriage. And if there was separation, it was on the family law side. So if there's a separation, it was mutual and there's a breakdown in the marriage. But for the most part, we're looking for cohabitation. It does account for situations where the spouse wasn't at fault for the separation. That's something just to think about the real world facts. We know that some of these conditions really have a really tough impact on veterans' relationships with those around them. So it's kind of accounting for that. There is a remarriage restriction, basically, built into this definition too. Generally, your surviving spouse cannot have remarried or even kind of lived with another person and held themselves out to be the spouse of that other person. That is something that's still baked into this particular definition. It can be if someone walks into your office and has, the remarriage issue, I'm going to point you towards some of those legal authorities to really dig into it, because there's a couple of subtopics here that can make this research particularly challenging. So I just want to flag that. Generally, when we punt to state law, here it is. The surviving spouse must have had a valid marriage with the veteran. VA will apply the law of the state where the marriage occurred. There is deemed marriages or something kind of thematically similar to the analysis that I would say about like voidable marriages, right, in most state jurisdictions. So nothing too out of the ordinary here, but just noting. Generally, the spouse will have been required to be married for at least a year leading up to the veteran's death. And it is worth noting that sometimes there can be competing claims for DIC. So if you have a common law situation, a common law marriage, then things are going to get a little bit tricky for that person. Again, I will say, despite all this, I've never actually seen a case in over 200 cases that I've handled. I've never had kind of the spousal requirement come up, but it's worth flagging because obviously, as you can see, there's a lot going on here. Remarriage, just some more specific. The timing of the remarriage is notable here. So that is potentially a fact that you would want to gather and just doing an intake with someone who's looking for DIC. I think just generally and in most cases, if you are in a situation where you are representing a veteran, obviously prior to their passing, best practice, if they are concerned with the financial welfare of their spouse, would be to get the spouse listed as a dependent on the veteran's file. So that requires the veteran to be receiving over a 30% rating. And what that does is it just has VA acknowledge that this person is their spouse. So I know that's not always the case. Sometimes you have the spouse coming to you asking for benefits after the veteran has already passed away. But generally, if you have some control over that particular timeline, that can be a way to ease that kind of inevitable transition when it comes up. So why do folks want DIC? I mean, fundamentally, it's a tax-free benefit. So this is going to be money that goes directly in the spouse's pocket. We'll talk about children in just a moment, but these are what some of the rates look like. So I had received that question in the chat about DIC versus survivor's pension, right? Here's some of the numbers here. So at a very basic level, $16.12 per month is what a surviving spouse would get for DIC. There are some increased rates based on different factual scenarios present. There is under the 38 USC kind of 13, let's see, it's like 1318. There are some even more favorable provisions for those veterans who were totally disabled at the time of their death due to their conditions. You see here in this second and really third column that there's an increased rate for spouses under that situation. If there are children in the household, right, there is some increased pay, including a transition, after the veteran's death, and then an increased amount for every year thereafter. If the spouse is housebound, it accounts for that here, and aid in attendance as well. So just to note that there is kind of a graduating scale of DIC. So it's not just one flat rate, but that flat rate can help you kind of estimate like, okay, is this something that might be helpful to my particular client? It's worth noting one thing that really distinguishes this from pension is this is not a needs-based program. This is more kind of flat eligibility. So it does not take into account the financial assets of the surviving spouse, or, as I'll talk about right now, their surviving child. However, let me just caveat, a surviving parent does have a needs-based component. So just to say, child does not have a needs-based component, parent does. Those are two big differences here. These similarly, some of the definitions of what we look at when it comes up to DIC. A child is generally, just to kind of translate this over, it's going to be a minor, or it's going to be someone over 23 who's pursuing education or training. So when we say child, we mean that pretty specifically, or at least the VA means it pretty specifically. Generally, child is not married, and they're not included in surviving spouse's compensation, and they're under 18. Now, I'll tell you a story in just a few minutes when we get into kind of the service connection piece of things about a child that I represented in a request for DIC based on her father's death. So I'll hold that in a little bit more for you. Parent, a surviving parent is not something that comes up all of that often, I would say, but it's worth to note that there are specific rules that apply to that as well. Generally, you're looking for a parent, an adoptive, or a foster parent of a veteran. There is this definition has a bit of a temporal component because it really kind of seems to require that they kind of step into this parenting role within a year before the veteran entered into service. So kind of a temporal requirement butting up right against their entry into service. There's also a little bit of a last in time component too. If you're looking at these definitions and thinking, wow, that's completely unworkable, that is something that I know has been voiced by a number of different veterans advocates. Elena has a great question. Can foster children of the veteran count as children, or if they have guardianship over a family member? My gut instinct is probably no, and that's one of the limits to this definition. It's not nearly as kind of encompassing as I think we all on a human level would hope it to be. We'll see what Eugene has to say. But there's just to say that this area is pretty ripe for some legislative intervention, in my view, at least, to kind of expand this definition, because families look a lot different than, they encompass a whole bunch of different scenarios. So now, so we've got surviving spouses, we've got a surviving child, we've got a surviving parent. Let's talk about the actual analysis here. So fundamentally and similarly to service connection, what you would need to prove to actually prove that your eligible person should receive DIC is that the veteran's death resulted from a disability either incurred in or aggravated by the line of duty. So this could be active duty service, inactive duty for training, and inactive duty for training. One thing I want to raise for all of you right now is it does not actually require the veteran to have been receiving service connection at the time of their death, right? So we can do a bit of a retrospective analysis to say that the veteran's cause of death was related to their service, even if the VA had not put in that analysis. So that encompasses a couple of different factual scenarios here. I've laid out kind of two, I would say, there's a few actually, we'll say 5 different ways that DIC could potentially be awarded. Generally, the case that we don't see often is when the veteran, who would then pretty much be a service member, passes away during their military service. So my understanding is that there is a collaboration between the Department of Defense and the VA to basically, when that happens, get the person's surviving spouse, family members who would be eligible, hooked into the VA system. So I have not, just to say, I have not seen that case, and I hope and think that those folks are being well taken care of through that collaboration between the two federal agencies. It's worth noting that it's possible, though. Now, far more often is what you find in the second bullet here, where the veteran passes away as a result of or aggravated by their service-connected disabilities. So to me, and just thinking about this in some of the cases that I've handled, that comes down to kind of three different analyses, I suppose. So there's the traditional service connection piece, which, similar to what Carter was discussing, kind of requires those, if it's direct service connection, the three elements, right? A current disability that is here, the cause of the veteran's death, an in-service event that occurred, and then a medical relationship between those two things. Here, unlike when you have a veteran who is living, VA will and should be providing the survivor with a medical opinion, since of course an examination is no longer available on the basis of, the veteran having passed away. So that's something I really want to talk to you all about very quickly, because in my experience, VA is awful about complying with its duty to assist when it comes to widows. I'll use widows as kind of an all-encompassing term for survivors. In the cases that I've handled, VA does not send when a widow files for DIC, and VA is supposed to go through and do this duty to assist to help them support their claim to include a medical opinion. Oftentimes I see them not doing that at all. And I just want to kind of establish that they should be doing that. They're terrible at doing that. And we've got a few rules that talk about that, mostly coming out of the Federal Circuit. So there's a case called Wood v. Peak that establishes pretty much that VA should be providing these folks, these vulnerable widows who've just lost their people, with a medical opinion. And the only reason they shouldn't be providing them opinion is if there's no reasonable possibility of substantiating the DIC case, that's a very low threshold, and most factual scenarios are going to exceed that. So just pardon me as I get on my soapbox, but that's something that I've seen a lot of that definitely fuels me in doing this particular work. So just to say, direct service connection is one thing. I think Link had pointed out in his question, it sounded like it's an Agent Orange exposure theory, for example, right? Presumptive conditions, presumptive causes of death are also viable. So it's going to be, veteran passed away from one of the cancers listed in the Agent Orange presumptive conditions. Lo and behold, that person was exposed to Agent Orange, and VA has already agreed that those two things are linked. So DIC should be warranted. Now, I'll talk about in a minute ways that can get more complicated, and I'll talk to you about a few of the stories of cases that I've handled here. But just to say, there's a nice slotting in of kind of the traditional analysis in the DIC context. That being said, that's not the end of the analysis, because there are either kind of I don't know if I would, maybe they would be alternatives, maybe they would be supplemental theories, not in the usage of the supplemental claim, but 38 CFR 3.312 does establish, and these are just two, but there's a few different pathways that get to the end result, which is DIC. So a survivor would need to show that the veteran had a service-connected disability, so either actually service-connected or should have been service-connected, that singly or jointly, with something else that they had going on, was the immediate or underlying cause of their death. So that's generally talking about kind of the primary cause of death. The other theory has a service-connected disability, again, actually or constructively, that contributed substantially or materially to their death. So this does kind of widen out the analysis, in my view at least, widens out the analysis from just like purely direct service connection. And so you can kind of incorporate these different theories here. Again, all of this is still to the tune of the at least as likely as not standard. So we are we're not necessarily working with a degree of medical certainty. That's not what we need to prove. It's that there was some kind of relationship that at least as likely as not resulted in the veteran's death, and so their survivors should receive DIC. So let me talk to you about two different cases that I handled. I'll start with, under the facts of this particular case, a younger veteran, an Operation Enduring Freedom, Operation Iraqi Freedom vet, was found dead in his home in 2020. His death certificate listed that he passed away due to the combined effects of fentanyl, amphetamine, methamphetamine, fluoxetine, and what was called the designer opioid 4-ANPP. So basically, under some theory, right, it's a drug overdose, hopefully unintentional, because that just takes it to a whole nother level of traumatic. But basically, this young veteran has passed away. I was contacted by his ex-wife to see if their minor daughter was entitled to any VA benefits. I want to stop and just pause here in a moment and note that the ex-wife would not be eligible. She had since remarried, right? So she would not be eligible for DIC, but the child, who was a minor, absolutely could. When it comes down to the nitty-gritty signing of the forms, in that particular case, the mother could sign off on the child's behalf. So I just want to flag that we've got a couple of different intersections here, but that's worth noting that that's possible. So I had the opportunity then to look into the veteran's records. It showed that he was service-connected for PTSD at 30%, and that was based on his experiences during 3 combat deployments. He had sought treatment at the VA healthcare system. So that's always, for those who don't often practice in this area, that's going to be a huge kind of reservoir of information for you to tap into. Now, facially, drug overdose looks like that's going to be tough, right? How do I show that a drug overdose was related to military service? Just quickly to say, through a really thorough review of his records, it showed that he was being prescribed fluoxetine, an anti-anxiety, antidepressant for his symptoms, right? He was prescribed amphetamine, which is a psychostimulant for his impaired attention symptoms, right? Both of those coming from the VA. And here, his hospital records show that he's reporting that he's using alcohol, he's using opiates, to include like fentanyl, methamphetamine, et cetera, to self-medicate his symptoms here. And he would use them once he ran out of his meds. There's some really poignant information, right? He used those as liquid medication in an attempt to really obtain kind of immediate gratification from his symptoms. So I tell this story for a couple of different reasons. Number one, just to point out kind of that relationship between a former spouse, a child, but also to say, those records here, it really operated like a closed world analysis, right? You just had to review the records of the veteran and then put those pieces together. We were able to argue that one, if not every single one of those conditions listed on his death certificate were the cause of his death. And all of those were related to either service-connected PTSD or his combat experiences generally. So worthwhile noting there. It's also worth to note, keep an eye on your personal biases when you're evaluating some of these cases, right? Drug overdose doesn't immediately point to some of these things, but lo and behold, there it is. And we were able to get her that particular benefit. Some of those, just to pivot slightly, represented another veteran, and this is a surviving spouse case. Her husband passed away from gastroesophageal adenocarcinoma in 2019. His death certificate reflected that he passed away from a malignant neoplasm of the stomach. Noteworthy because I will put big money on this, that the thing that the regional office is going to do the moment you file a claim for DIC is they're going to look to the death certificate and the condition that's listed on the death certificate. If it is the same verbiage as one of the service-connected conditions, they'll grant that, and that'll be easy. But the vast majority of cases, that language won't line up. It is possible, and I know of advocates, even in our office here, who have worked to get death certificates amended to reflect the language that's helpful. I just want to flag that that's a possibility. That's going to be the quickest route if you have someone who's desperately in need and time is of the essence. other than that, here we had to prove this was a Vietnam veteran and was rated at 100%. Came back from Vietnam a wholly different person, and had some polysubstance use issues, which we were able to obtain an independent medical examination to say, you know, the cancer that was the cause of his death was related at the very least to the substances he used to self-medicate, but fundamentally that was related to his service-connected PTSD as well. So these causal chains can be quite broad. And it's worth to keep a really, really open mind on this particular chain. Let me just say one thing worth flagging here. The veteran at his time of death was totally rated at 100% for PTSD. But unfortunately, he had not been rated at that rate for long enough to make DIC automatic to his spouse. So in that provision that I pointed you guys to in 38 USC 1318, there are special rules for those who are totally rated. We get people who contact us all the time who are like, I want TDIU, I want 100% because I want my survivor to get benefits. That's kind of what they're talking about here. So I just want to note that there's a temporal component that you have to have been totally rated for a set period of time to make that automatic DIC to the spouse. Okay, let's see. So these are just a couple of different theories. Again, keep an open mind. This is a area that's rife for creativity. And so I would encourage all of you who are interested in doing VA work, you know, look out for those survivors, because it can be a closed record system. It can be an amazing area of analysis, and VA sometimes does a criminal job of handling these cases. Now, these are the rules that I just alluded to. This is the 10-year kind of easier way. So if a veteran dies of any particular reason, but they were at 100% for a service-connected condition, it makes it a lot easier for the widow. It's a big motivator for folks in contacting us. Last but not least, let me just say, how do you file for it? If you are helping a survivor file for the first time, you're going to file this particular form, a VA Form 21P 534. Noting, particularly Link, I'm talking to you based on your question in the comments earlier. If you file this form or an intent to file within a year after the veteran's death, and you are later able to show that DIC is warranted, it will date back to like the first day of the month following the death. So there's potentially an extra year of benefits. You don't have to, have started that temporal chain. You can file a supplemental claim. So there you're going to need new and relevant evidence, as Martha chatted about earlier in this presentation. So again, lots of really great work to do here. And let me tell you, these facts are heartbreaking. You learn so much about people. The widow I was chatting about earlier, she told me the story about how her and her husband, who was in the throes of PTSD, sat in the 8th row of an Elvis concert. And because the severity of his symptoms, he just sat down and ignored Elvis the whole time, right? Where else are you going to get stories like that? So just to say, that's DIC in a nutshell. And I'm happy to answer. I know Eugene and I are happy to answer any questions you might have. So feel free to drop those. Yeah. Let's see. I have a spouse of a veteran that was killed in a motorcycle wreck. An honored death certificate that states cause of death alcohol. She has service connection for PTSD. Is it possible for him to submit DIC? I think so, just facially on those facts, so long as there's a relationship between her alcohol use and her PTSD. That's something, I see Eugene nodding too. That's something we see a lot of. And you'll have seen in these two examples, like this, there's a lot of self-medication, there's a lot of toxic exposure issues. So I would say that's something worth exploring for sure. Thank you, appreciate that. I can tell another story or two if we want to hear it, but I also know all of your time.
I have a few as well.
Yeah.
No, I was just, I've been around for a while, so I've got a few stories.
Yeah, we got a couple. Would it be considered willful misconduct? So I think that's a great gut instinct. And that's one thing that I know I have to catch in myself when I see some of these situations. Self-medication of a mental health condition will take it outside of willful misconduct. But if it's pure kind of substance use without a mental health component, then you're gonna be facing a lot tougher of a fight, and you might get hit with VA saying it is willful misconduct.
Well, and there's been some cases where a suicide has been linked to, um, PTSD and stuff like that. So, there's a lot of variables that you don't know what's going on with a alcohol involved motorcycle accident. If
Yeah.
they're doing, if the police report shows they were doing 100 miles an hour on a motorcycle and blood alcohol content is over the legal limit, there's a suicide question there that needs
Right.
to be asked.
It's true. That is true. There's one, and just to flag, I always flout this as my favorite non-precedential case that's ever been issued by the CABC, but there's a case called Trevino v. McDonough, where it's this really horribly tragic fact pattern where it's a veteran who was assaulted when he was serving in Korea, felt so much shame about that particular event that he never talked about it, and he never ever even considered seeking treatment or therapy for it. And it culminated in a suicide years later. And so his widow asked for DIC, and there was no treatment record at all. And he didn't talk to anyone about it too. So it was really kind of a big, you have a lot of circumstantial facts, but it's a struggle. It can be really hard to prove like that's exactly what was going on at the time. But it's a fact pattern that pops up, as Eugene has noted. So these are also, let me just flag, these are incredibly hard cases to say no to, just on a human level when confronted with someone. So I think that's part of the reason why I'm counseling you all to just kind of really dig into the facts of the particular case and learn as much as you can about it. And just making sure that you do review those records, because those can be gold mines. And, if you have to say no, sometimes you do, but you'll have done it with a full kind of reasoned analysis here. So anyway, that's, I'll stop talking now. And let's see. Sounds like Mark Galler has a difficult DIC claim. They do exist. They are a thing. Yep, I've got stories, but no need for that. So for now, unless we'll do last call and questions, but other than that, Eugene and I will hand it over to Lucas. Oh yeah, treatment outside of the country can make it incredibly difficult to gather evidence about it. Power to you. Oof. Okay, thanks for sharing that, Mark. And Lucas, you want to close us out?
Yeah, of course. Thank you all so much for coming on this afternoon. I just want to recap why it's easy for you to help in these situations. Of course, first off, VA disability compensation is a very interesting area of the law, and the clinic will actually provide mentorship and support as you're going through cases. Of course, veterans law is also very veteran friendly and non-adversarial compared to what you're probably used to. Of course, there's no trials, no paperwork and records, and no opposing counsel to deal with unless you're going like really high up. Standard of proof is as likely as not, which is something that most of us aren't used to. It's a more liberal standard of proof than other areas that you are more likely to encounter. And there are a few hard deadlines in veterans law, and there's new evidence that can be submitted during the appeals process to strengthen the claims. And of course, hold on just one second. How do I slide?
It's
Oh, my apologies. And of course, and here's how you can help. Later today, you're going to get an email sent to you with a link to the web page that you can download the slides from this presentation, complete our CLE evaluation form, and actually to sign up to join our attorney referral program. And of course, request a CLE certificate if you're not a Missouri attorney. As a reminder, CLE credit is only available for those of you who viewed the live webinar today. And one more slide. And of course, thank you for taking this time. I know your time's valuable. Of course, just thank you for taking it to learn more about veterans benefits and the process that veterans must go through to obtain them. Of course, the Mizzou Veterans Law Clinic is here to serve as a resource to you as you advocate on behalf of our nation's veterans. We wish you a happy Veterans Day on Monday. And for those of you on this webinar who are veterans, thank you for being willing to lay your life down in service to this nation. Thank you very much.